All right, first case you guys wanted me to call was Robles, 2021 CT 997 AW. Good morning, ma'am. Can you tell me your name? I can't hear you.
Rachel,
What's your last name, Rachel?
Robles.
Is your last name Robles? All right, ma'am, you're here in case 2021 CT 997 AW on charge of driving under the influence. That's a first-degree misdemeanor. It's punishable by 180 days in the county jail and a $1,000 fine. Ms. George, you have a plea you want to enter on behalf of Ms. Robles.
Yes, Your Honor. We're going to enter a plea of not guilty.
Ms. Robles, I'm going to accept your attorney's plea if not guilty on your behalf. I want to set you for Division 62.
Our conference, July 19th at 9 a.m. in 9B.
All right, have a great day, ma'am. Good morning, sir. Can you tell me your name?
Justice Rubio.
Is your last name Rubio or is your last name Figueroa?
I have two last names.
Okay, it's Rubio's your first last name. All right, Mr. Rubio, you're here in an out-of-county warrant from Polk County in case 2020 CF 9750. Judge in Polk County set your bond at zero. Your bond's going to remain at zero. I'm going to appoint the public defender to represent you in this case. In order that you have no contact with these victims or these victims' families while you're here in the jail, and we'll get you on to Polk County as soon as possible.
So does that mean when I go to Polk County, I have to
Yep, you're going to see a judge, initial appearance judge. Kind of looks like what we're doing here. But until that happens, no contact with any victims, witnesses in that case, no contact with any individuals, victims' families. You understand that?
and I have no bond until I see that judge.
Yep, so that may change. We're going to appoint an attorney here, and you're probably going to get another attorney when you get over there to Polk County.
Okay.
But technically, you're not entitled to a bond based on the charges you're facing. So we'll get you on to your judge and see what they feel like is appropriate.
Okay, thank you.
Good morning. This is Dalia Romero, Spanish interpreter on the line, already sworn in today.
Good morning, Ms. Romero. This is Judge Bain calling from the BRC. I need your assistance with a few cases this morning. I have a defendant with the headsets on. If you can see if we can make a connection.
Le escucho perfectamente.
He can hear perfectly.
Right. Good morning, sir. Can you tell me your name?
Buenos días. Walter Eduardo Medina Calderón.
Walter Eduardo Medina Cardadon.
Mr. Medina, you're here in case 2021 MM4151AO on charge of battery domestic violence. I reviewed the
Sorry,
charge.
Your Honor, can you repeat that for the interpreter? I'm getting a really bad echo.
Sorry. He's here in 2021 MM4151AO on charge of battery domestic violence. I reviewed the charging affidavit in the case, did find probable cause for his arrest. Going to set his bond amount of $250. It's going to come with pretrial release supervision. He has to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may need while the no contact order is in place. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. Do you have any questions about the no contact order, sir?
Sí, señor juez, me gustaría exponer brevemente porque no tomé un abogado en virtud de que yo conozco la situación y quería expresar acá.
Your Honor, I would like to say something of the reason why I didn't take on an attorney, because I wanted to explain the situation here.
Well, sir, this is not the place to discuss the facts of your case. Everything you discuss with me can be used against you at a later date, at a trial or any other proceeding. Right now, my question is, do you understand the no contact order that's in front of you in Spanish?
Esa parte sí entendí, lo que me gustaría es que me repita el tema del valor y de las 24 horas.
That part I did understand. I would like to have explained to me the amount and the 24 hours.
You have 24 hours to turn over any weapons or firearms once you're released. Bond amount is $250. You're going to be supervised with what we call pretrial release services. So you have a pretrial release officer who's going to keep track of you while you're out in the community. You still haven't answered my question. Did you review the no contact order? Do you have any questions about it? Because if you violate that order, I'm going to hold you in jail. I'm not going to let you out. You understand that?
Sí, entiendo perfectamente, pero de por medio existe un trámite que está por empezar, que es del divorcio. Entonces, ¿cómo puedo tomar yo contacto con la víctima, con la demandante?
Yes, I understand, but there's another legal process of the divorce.
Okay.
And how am I able to communicate with the plaintiff?
You need to get an attorney.
El abogado puede tomar el contacto con las dos partes para hacer el trámite.
So the attorney is able to communicate with both parts
That's
for
their
the
job.
process?
The job is to communicate between the parties, to communicate with the court. You personally are to have no contact with the victim. Now, you cannot use your attorney as a conduit to harass, bully, abuse, or assault the victim. Do you understand that?
Entiendo perfectamente. El otro tema es que la casa es mi casa, está a mi nombre y cómo voy a salir de la casa. Esa parte quisiera saber cuál va a ser a dónde me voy.
The other issue is the house belongs to me, it's under my name. And when would she leave the house, or where would I go?
I don't know, but if you're married, it doesn't matter if the house is in your name. It's a piece of equitable property that can be dispersed. Unless you receive that property through an inheritance. So,
I'm sorry, Your Honor, can you repeat that for the interpreter?
unless he received the property through an inheritance, like your grandmother or your mother gave you this house, if you bought this house and you guys are married and living in it, that is the house for the family. So you cannot return to the house if she's there. You cannot have any contact with the victim. You can't be within 500 feet of the victim. You cannot use any electronic communications device to contact the victim. You cannot have any contact with this victim whatsoever. So if you're having problems understanding that, I suggest you talk to your family law attorney. I'm also going to appoint a public defender to represent you. But you understand that's what's going to happen. If you violate my order, you're going to be here with me.
No va a tener contacto. La última pregunta es poder recoger mis cosas de la casa para poder salir a alguna parte.
No, I will not have any contact. The last thing is, how can I go back to the house to pick up my belongings?
I told you I gave you a one-time return with law enforcement. So you need to follow the procedure outlined to you by the pretrial release officers, contact law enforcement, and work with them to go to the house and get your stuff that you need. Now, you're not going to be able to take TVs, couches, sofas, furniture, but you'll be able to take clothes, tools, things you need for work, personal items, medication, all those kind of things like that. And once you guys are done with your divorce, your family law attorney, your judge will enter the final judgment telling you who gets what property. But until that happens, and as long as this case is outstanding, you'd have no contact with the victim. Do you understand?
Está bien. ¿En qué momento puedo ir con el señor oficial a recoger mis cosas?
So at what time can I go back to the officer to retrieve my things?
You're not listening. I don't know if you're having a problem with the interpreter understanding what I'm saying. But I said you must contact law enforcement. I'm not giving you a specific time. I'm not a time clock. I don't organize their shifts or what they have to do. You need to abide by their procedure. So have a great day, sir.
Gracias.
Was that the only case for the interpreter, Your Honor?
I believe so, Madam Interpreter. Thank you for your help this morning.
You're welcome. Have a great day.
Thank you. You're before the court at this time for an arraignment for an alleged violation of probation. Your attorney has filed a notice of appearance and enter a plea of denial on your behalf. The clerk will announce your court case at this time.
Good morning, ma'am. Can you tell me your name?
Zainab Otiki.
And counsel, can you put your name on the record?
Good morning, Judge Darrell Smith on behalf of Ms. Otiki.
Ma'am, you are here in case 2021 MM 242AA on charge of battery. I did review the charging affidavit in your case, did find probable cause for your arrest. Mr. Smith, you want to tell me anything before I set release conditions as to this case?
Not as to this case, Judge.
All right. All right, ma'am, I'm going to set your bond in this case amount of $1,500. It's going to come with, sorry, you don't qualify for pretrial release. You had no contact with the victim in this case. You have to not return to the scene of the location where this incident happened. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. State, are you asking for any other conditions?
No, Your Honor.
All right, Mr. Smith, I guess you want to tell me about this out on bond case.
Yes, Judge. As to that, I represent her on that. That is a DUI. I would ask that the court take no action as to that case. Ms. Otiki has no prior criminal history before that particular DUI. This particular domestic violence incident, I've talked with the victim who's the mother. Unfortunately, they're kind of going through some back and forth stuff in the household, but Ms. Otiki really has no criminal history. She's young. I would ask that the court take no action as to that.
All right, I couldn't tell because it seems that, does she live at this residence where this happened?
She does, Judge, but I believe since a no contact order will be in place, she'll be going elsewhere. I think that'll help with the issue.
So I'll strike the no return. I'll say maintain a separate residence. I'll give you a one-time return with law enforcement to retrieve your property, personal property you have at the location.
An attorney from the public defender's office is present to enter a plea on your behalf.
I'll do this as to your resisting case in 2021 MM 195AA. I'm going to revoke your RR status. I'm going to set bonds in your cases amount of $500 on each count. Condition of your bond that you not possess or consume any drugs or alcohol without a valid prescription. That you also not operate a motor vehicle without a valid driver's license. You have, Mr. Smith, you can represent on a new case as well?
Yes, Your Honor.
So you have representation as to both your cases. You have a great day, ma'am.
Thank you, Judge. Good to see you. Have a good day.
You too. All right.
Welcome to an Econo meeting. You are entering the meeting now.
All right, well, thank you all. I appreciate everything, and you have a good day. Thank you, council.
All right, there we go. All right. Good morning, sir. Can you tell me your name?
Amin Hainawi.
And counsel, can you put your name on the record?
Good morning, Your Honor. Harold Thompson on behalf of Mr. Hinawi.
Mr. Now, you are here in case 2021 7115 AO on charge of battery, domestic violence by strangulation. I did review the charging affidavit in your case. I did find probable cause for your arrest. Mr. Thompson, do you have anything you want to tell me before I set release conditions in this case?
Yes, Your Honor. I just would like to ask if we can set a reasonable bond in this case. My client has a 5-month-old child in common with the alleged victim. I actually spoke with the victim today, but not to put into any hearsay out on a record. She does want him to have access to speak with, her in regards to the child. So I would ask if we can have no hostile contact. If you're not inclined to do that, I can follow up and file an affidavit that supports this notion. He's, of course, my client is not opposed to not going back to the residence until we can get everything cleared out.
All right. Mr. Thompson, I need the victim here testifying. So because there's several questions I have to go through with her where the court can feel comfortable giving her contact with the defendant as well as the statements of Mr. Ennis' affidavit are concerning to the court.
Yes, Your Honor.
Mr. Howard, I want to set your bond in this case amount of $2,000. It's going to come with pretrial release supervision. You to have no contact with the victim in this case. You're going to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at the residence. You may not possess any weapons or firearms. Any weapons or firearms you have may need to be turned over to law enforcement within 24 hours of your release. Do you have any questions about the no contact order, sir?
No, sir.
All right, you have Mr. Thompson representing you in this case.
Yes, sir.
So use him as you must use him to make sure that you don't violate my orders. All right, have a great day, sir.
Thank you so much, Your Honor. Might be excused.
Yes, sir.
Good to see you, Judge.
We're doing arraignments first? That's what. Oh. Just saying. All right. Good morning, sir. Well, I have Barrios Ramos is my first person. All right, this is case 2021 CT 531AA. Represented by the Public Defender's Office. She's here for arraignment on a charge of leaving the scene of an accident with property damage.
I'll waive the appearance rule.
All right, we're going to set her for Division 63.
Division 63 pre-trial conference, July 22nd at 1 p.m. and 12 p.m.
Good morning, sir. Can you tell me your name?
DeAndre Jerome Bowen.
Mr. Bowen, you're here in case 2021 CT 3962AO on charge of driving while license suspended driving license suspended with knowledge. That is a second-degree misdemeanor. It's punishable up to 60 days in the county jail and a $500 fine. Say it was an offer that you wanted to convey to Mr. Bowen.
Yes, Your Honor. The offer that was conveyed was an adjudication credit time served.
Mr. Bowen, do you want to accept the state's offer of adjudication of guilt credit time served in this case?
Yes.
Do you have an opportunity to review a plea form? All right, why are you doing that? Can you write one up for me? Let's have a conversation. Let's talk while they're doing that. Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this case is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You put your hand down, sir. Sir, you're here again in case 2021 CT 3962AO on charge of driving license suspended. That's a second-degree misdemeanor. It's punishable to 60 days in the county jail and a $500 fine. It's maximum penalties. You understand that? You understand?
Yes, sir.
Do you want to enter a plea of guilty or no contest in this case?
No contest.
No contest.
All right. You understand by entering a plea of no contest, you're going to be waiving your right to have a trial in this matter.
Yes, sir.
You understand you're waiving your right to have an attorney appointed to represent you if you cannot afford it?
Yes, sir.
I can't hear you.
Yes, sir.
All right,
My apologies.
no problem. You understand you're waiving the right to challenge the state's evidence, question their witnesses, and call witnesses on your behalf?
Yes, sir.
You understand that if you want a witness to appear and that witness did not want to come to court, I can use my subpoena power to make that witness appear?
Yes, sir.
You understand you're waiving your right to remain silent in this case?
Yes, sir.
You understand you're waiving your right to appeal any errors in this case except my jurisdiction over you and the sentence I'm going to impose?
Yes, sir.
All right. So there's a lady downtown in downtown courthouse that's listening to whatever we're saying. It's going to later type everything up. So she can't see this or this, okay?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand that a later conviction for the same offense can enhance your sentencing up to a third-degree felony?
Yes, sir.
Can the state give me a little facts about this case?
Yes, Your Honor. On or about May 23rd of 2021, Mr. Bowen was driving on South Orange Blossom Trail at approximately 9:27 p.m. when law enforcement initiated a traffic stop. Mr. Bowen's license has been revoked since 2017. He was driving without a license. All events occurred in Orange County, Florida.
All right, Mr. Bowen, the court's going to find a factual basis based on the recitation from the state of Florida. I'm going to accept your plea of no contest. I'm going to find your plea is freely and voluntarily entered. I'm going to adjudicate you guilty as a charge. I'm going to give you 4 days credit time served. The cost of prosecution in this case of $306. I'm going to give you 2 years from today's date to pay that money directly to the clerk in full. You got 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Yes, sir.
And this is case 2021 CT 572 AE. Ms. Thomas is represented by the Public Defender's Office on a charge of driving under the influence of blood alcohol level above 0.2.
I'll waive the appearance and enter a plea of not guilty, Your Honor.
All right, we're going to set her for Division 81.
Division 81, pretrial conference, July 16th at 9 a.m. and 4 p.m.
Good morning, sir. Can you tell me your name?
Roy Delva.
Mr. Davila, you're here in case 2021 MM4003AO on charge of criminal mischief. That's a second-degree misdemeanor, punishable by 60 days in the county jail and a $500 fine. Do you understand that?
Yes.
Did he not have an attorney in the felony case? Ms. George, did you guys represent him in the felony case, and you should be representing him now?
He is represented in the 4003 case. 5481.
But the 5481, nobody ever gave him a public defender? All right. All right.
Yeah, we have him.
Okay. So you're represented by the Public Defender's Office in your case, so you have an attorney. Ms. George, do you want to enter a plea on behalf of your client?
Yes, Your Honor, we'll enter a plea of not guilty.
All right, sir, we're going to set you for Division 82 for pretrial conference.
Division 82, pretrial conference, July 26th at 10:30 a.m. and 10 p.m.
All right, have a great day, sir.
Randy Oliver is next, Your Honor.
All right, this case 2021 MO 633 AO on Mr. Randy Oliver. He's represented by the Public Defender's Office.
I'll waive and enter a plea of not guilty, Your Honor.
All right, we'll set him for Division 81.
Division 4E.
Good morning, sir. Can you tell me your name? Mr. Smith, you're here in case 2021 MM 3999AO on a charge in count one of trespass on property other than a structure or conveyance, and in count two, petty theft with a prior theft conviction. Both of those are first-degree misdemeanors. Both of those are punishable up to 1 year in the county jail and a $1,000 fine each. Do you understand that?
Yes, sir.
Ms. George, what plea you want to enter on behalf of your client?
Your Honor, the state's not making an offer. However, my client wanted to see if the bench would be willing to accept a bench plea.
Is this like a Walmart case or something, or?
It came in as a Burke structure, trespass, petty theft. We didn't file the Burke structure. The basic facts is he jumped behind the counter and grabbed cigarettes. We only filed the trespass and petty theft. I was just not willing to offer a credit time served offer at this time.
What's his history?
He just pled to, I believe it was in front of Your Honor, he just pled to a trespass in April. He pled to one in 2020 at the end of April or end of October, another one in 2020. So it seems to be an ongoing problem, but given the facts in this case, I was not willing to offer credit time served, which is all I'm able to do today, Your Honor.
And it's only the one prior theft? Does he have any other withholds and anything like that?
It's a rather lengthy history.
All right, here we go. All right, so I see one grand theft, fraudulent use of personal fraudulent use of a credit card, and 2 counts.
I have a no valid from 2002.
I'm just looking at you. Ms. Davis just gave me his face sheet, or at least a history in his face sheet. All right, Mr. Smith, if you want to plead to me, I'll give you 60 days in the county jail, 60 days credits, like for the 40 days you spent in Orange County Jail with the court costs and cost of prosecution, PD lien and PD app.
Yes, sir.
All right. But you understand if you get convicted of another theft, it's going to be a felony. You understand that?
I understand, sir.
All right. Can you raise your right hand to be sworn in? You solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
All right, put your hand down. Sir, you're here in case 2021 MM 399AO on count 1, trespassing the property other than a structure or conveyance. Count 2, petty theft with a prior theft conviction. Both of those are first-degree misdemeanors. Both of those are punishable up to 1 year in the county jail and a $1,000 fine each. Do you understand that?
Yes, sir.
You want to enter a plea, Ms. George, your client's entering a plea of guilty or no contest?
No contest.
Mr. Smith, you understand by entering a plea of no contest, you can waive your right to have a jury trial in this case?
I understand, Your Honor.
Do you understand you waive your right to have Ms. George and her office represent you at that trial?
Yes.
You understand you're waiving the right to challenge the state's evidence, question the state's witnesses, and call witnesses on your behalf? If there's a witness you wanted to call, I can use my subpoena power to make that witness appear. Do you understand that? Do you understand you're waiving your right to remain silent?
Yes.
You understand that you are waiving your right to appeal any errors in this case except the court's jurisdiction over you or the sentence I'm going to impose?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand that a later conviction in this same offense can cause you to be sentenced as up to a third-degree felony?
I understand.
Based on a short recitation from the state, I do find a factual basis for the hearing of your plea. I accept your plea of no contest, find your plea is freely and voluntarily entered. I want to adjudicate you guilty of the charge. I'll give you 60 days in the Orange, I'm going to sentence you to 60 days in the Orange County Jail concurrent on each count, and give you 40 days credit time served on each count. The court costs, the cost of prosecution in this case are $273. There's a $50 public defender application fee and a $50 public defender lien. I want to give you 2 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand that?
Sir.
All right. Have a great day, sir. Good morning, sir. Can you tell me your name?
That's Gregory Stepp.
Mr. Stepp, you're here in case 2021 MM311AW on a charge of trespassing occupied structure or dwelling and resisting an officer without violence in count 2. Both of those are first-degree misdemeanors. Both of those are punishable up to 1 year in the county jail and a $1,000 fine each. Do you understand that?
Yes.
Ms. George, what plea would you like to enter on behalf of your client?
Your Honor, we're going to enter a plea of no contest. The state's offering an adjudication of guilt, credit time served, no return to Advent Health, Winter Garden, absent a medical emergency. And Mr. Stepp would like to accept the state's offer here today.
All right, Mr. Stepp, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Sir.
You can put your hand down, sir. Sir, you're here, like I said, in case 2021 MM311AW, charged of trespassing occupied structure, resisting officer without violence. Both those are first-degree misdemeanors. Both those are punishable up to 1 year in the county jail and a $1,000 fine each. Do you understand?
Yes.
Do you want to enter a plea of no contest to resolve your case today? Do you understand by entering a plea of no contest in this case, you're going to waive all the rights listed out in that plea form that's in front of you?
Yes.
Has anybody forced, threatened, or coerced you to enter this plea? You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
Yes.
Have you now or in the past been diagnosed with a mental health illness?
No.
And the party stipulates a factual basis?
Yes, Your Honor.
Yes, Your Honor.
The court accept that stipulation. I'll find a factual basis for the entering of your plea. I'll accept your plea of no contest, find your plea is freely and voluntarily entered. I want to adjudicate you guilty as to the charge. I'll give you credit for 26 days on each count, concurrent to one another, and with 26 days credit time served. The court costs and costs of prosecution in this case are $273. There's a $50 public defender application fee and a $50 public defender lien. All those costs will be payable directly to the clerk within 2 years of today's date. You have 30 days from today's date to appeal your judgment and sentence in writing. Do you understand that?
Sir.
All right, have a great day, sir. I can't, it's not really a legal prohibition. Who's going to enforce it? All right. Good morning, sir. Can you tell me your name?
Zachary Allen Baumgartner Siddell.
Say your last name again?
Baumgartner Siddell.
Mr. Baumgartner Siddell, you're here in case 2021 CF 7142AO on charge of aggravated assault with a firearm. I did review the charging affidavit in your case. I did find probable cause for your arrest. I'm going to set your bond in this case amount $3,500. Condition on your bond that you had no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement if you need it to retrieve any personal items you have at that residence. I think it's your house, but I don't know if she's still there.
She's already moved.
Yep, I want to make sure she's gone.
Got you.
You may not possess any weapons or firearms. Any weapons or firearms need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case, sir. You have a great day.
Yeah. Thank you.
Good morning, sir. Can you tell me your name?
John Dre.
Mr. Dre, you're here in case 2021 CF 6911 AO on a charge of sexual assault or battery on a person 12 years or older, or a person 18 years or older. You're also here in case 2021 CF 6911 on a charge of battery, domestic violence by strangulation, and here in case for your third count, battery, domestic violence. The judge signed your warrant. This case has already found probable cause for your arrest. Going to set your bond in count 1 in amount of $50,000, count 2 $10,000, and count 3 $5,000. Condition of your bond is you had no contact with the victim in this case. You maintain a separate residence from this victim. I'll give you a one-time return with law enforcement if you needed to retrieve any personal items you have at the residence. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case. You have any questions about the no contact order? All right. Have a great day, sir. Good afternoon, sir. Can you tell me your name? Mr. Turnbull, you're here in case 2021 CF 7147 AO on a charge of aggravated assault with a deadly weapon, false imprisonment, and resisting an officer without violence. I did review the charging affidavit in this case. I did find probable cause for your arrest. I'm going to set your bond in count 1 in the amount of $15,000, and count 2 $15,000, count 3 $100. Condition of your bond is you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items that you may have at this location. Before I continue, state, are you planning to file a motion for pretrial detention?
Not this time, Your Honor.
Do you read the defendant's alleged history and facts of this case before making that decision?
I'll reach out to DV.
Well, it's gonna be too late then.
They haven't told me they have any intention, Your Honor.
All right. You are to possess no weapons or firearms. The weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case. You have a great day, sir. Good morning, sir. Can you tell me your name?
Walter Cannon.
Mr. Canyon, you're here in case 2021 MM119AE on charge of battery, dating violence. Did review the charging affidavit in this case. Did find probable cause for your arrest. State, can you tell me about these prior domestic violence cases?
Yes, Your Honor.
Excuse me, sir.
1 second.
I have a 2005 misdemeanor battery, victim being Miss House. I have a 2012 misdemeanor battery, victim being Mr. Vokes. I have a 2016 misdemeanor bat DV, victim being Miss Norman. I believe that is it in Orange County, Your Honor.
Mr. Canyon, going to set your bond in this case amount of $1,500. Is going to come with pretrial release supervision. You to have no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return to a shared residence with law enforcement to retrieve any personal items you may have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be returned to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case. Do you have any questions about the no contact order, sir?
No.
All right. Have a great day, sir.
Eric Garvin, Your Honor, his mental health.
All right.
Victim is here, Your Honor.
Doesn't really help, dude. Sit them like way off where I can't see anybody back there. All right, good morning, ma'am.
Good morning.
Can you tell me your name?
Jacqueline Garbus,
Can you tell me, spell your last name?
G-A-R, B as in boy, U-S.
Can you raise your right hand and be sworn in?
Yes, sir.
Do you solemnly swear or affirm the testimony you'll give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. First things first, Mr. Garbus is represented, I'm going to appoint a public defender to represent him in case 2021 MM 4130AL. He's arrested on a charge of domestic violence.
I'll waive the appearance, Your Honor.
The court did find probable cause for the charge of battery domestic violence in this case. All right, Ms. Garbus, do you want to have contact with the defendant in this case?
Yes, I love my husband. I want him to come home. It was all an accident. I panicked and called the police, and I'm really sorry. I love him, and we need
Yeah,
counseling and stuff.
Nobody,
I'm-
these cases are not about somebody not loving or loving somebody else. So the question that I have, do you want to have contact with him?
Yes, sir. I want
Are
contact.
you afraid of him?
No.
Has there been any prior instances of domestic violence between you all in the
No.
past?
No, sir.
All right, I see some prior battery history in his past. Were you the subject of those batteries?
No, sir.
Did drugs or alcohol play a role in this incident?
Yes, he was. He had been drunk when he came home.
Is that an ongoing problem in your relationship?
It's an issue, yes, sir.
All right. They're telling me that cannot be brought because he's maybe having some mental health issues.
Okay.
Does he see a mental health professional while he's out in the normal? He's had normal appointments with a doctor?
No appointments. He's on a something for seizures and a mood stabilizer.
Okay. And does he get that? Where does he get that drug from? Like a psychiatrist, a MD?
No, I think I think it's his neurologist.
All right. So he doesn't see any psychologist or psychiatrist for any mental health conditions?
Not recently, no. We saw a couples counselor, but nothing else.
What
Nothing
individual
recent.
counseling for him?
Not for him. Not for he's been to a psychiatrist before, but not any time recent.
All right. When was the last time he's been to the psychiatrist?
A couple years ago, maybe a year ago, a couple years ago.
All right. You know the name of that doctor that he was seeing?
No, I don't have it on me. I don't know.
All right. Do you know where he was seeing the doctor at Aspire in Lakeside? Was he seeing it at a private facility?
It was a private.
All right.
And he had only gone a couple times.
All right. Say you got questions for the witness?
No, Your Honor.
And Ms. George?
No, Your Honor.
All right. I have one more question for you though, ma'am. You said you panicked, but the question still remains, if something like this were to happen again, do you feel comfortable contacting law enforcement?
Would I feel comfortable?
Yes.
Yeah, if I needed to, if there's something that was bad, but
What's your definition of bad? That's what I'm trying to ascertain.
if it was like, I would probably, at this point, I'd only contact if it was like a life or death situation.
All right. So
But I don't have any,
there's a lot of space in between that, because
but yes, I would feel comfortable if it need be.
all right, State, what do you think?
Regarding contact, Your Honor?
Yes, ma'am.
Regarding the affidavit, there is an allegation in it that the defendant has been physical before, however, it was not reported. I understand the victim's testimony here today. However, at this time, given his mental health status and given that allegation in the affidavits, they would ask for no contact and for the PD to file a motion later to allow contact.
All right, Ms. Garbus, I want to just kind of tell you how I process these kind of cases.
Yes, sir.
A lot of people think that just because this particular instance is, what they consider minor, or so I have people tell me there's a misunderstanding of the words that they usually use when they come to court today. But the separation between minor and what you described as life or death is usually very slight when it comes to domestic violence cases. It goes from pushing, shoving
Gotcha.
to extremely violent, usually very quickly. So for that reason, ma'am, in this case, I'm going to set bond the amount of $500 for Mr. Garbus. I'm going to place him on pretrial release in this case. I'm not going to give him any contact, so no contact with you while this case is pending. He must maintain a separate residence from you. You'll get a one-time return with law enforcement to retrieve any personal items he may have at that residence. He's also not allowed to possess any weapons or firearms. Any weapons or firearms he has needs to be turned over to law enforcement within 24 hours of his release. He's also not allowed to possess any drugs or alcohol while he's out on release. He's going to be subject to random drug and alcohol testing at his expense. Now, this case will be heard in front of Judge Wayne Shoemaker, and if those release conditions need to be modified by him, he has the power to do so. But in this current time, the court doesn't feel comfortable giving you contact right now. All right?
Okay.
All right, have a great day, ma'am.
Thank you, sir.
Good morning, sir. Can you tell me your name?
Good morning, sir. My name is Terrence Solomon.
Mr. Solomon, you're here in case 2021 MM 4142 AO on charge of resisting officer without violence and battery domestic violence. I did review the charging affidavit in this case. I did find probable cause for your arrest. We're going to set your bond in count one in amount of $500, count two $500. Condition of your bond that you had no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items that you need to have in this while you're out on this case. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm also going to appoint the public defender to represent you in this case. You have a great day, sir. Well, first, you got any questions about the no contact order?
The no contact order, I don't need to be in contact with him because we're in different ABNBs, so we don't need to be in contact.
Okay, I'm just don't violate my order.
All right.
All right. All right, we're gonna take a quick recess so I can deal with our extradition stuff. All right, let's go back on the record. Next person I have is Stoner. Good morning, sir. Can you tell me your name?
Daniel Stoner.
Mr. Stoner, you're here in case 2021 MM4147AO on charge of battery domestic violence. Did review the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in this case amount of $1,500. The condition of your bond is that you had no contact with the victim in this case. You are to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you may have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You're also not allowed to possess any drugs or alcohol without a valid prescription. You'll be subject to random drug and alcohol testing at your expense. I'm going to appoint the public defender to represent you in this matter. Do you have any questions about the no contact order?
How soon can I get my vehicle and my stuff from my premises?
Well, you got to call the police. You got to call the non-emergency number, set up with law enforcement.
The number right here.
That's your attorney's number.
They'll give me the information I need.
You can ask them on the way out. They may be able to probably give you that information. I don't know where jurisdiction you're in. I don't know if you're in Orange County Sheriff's or.
I think so.
Yep, then you can call them.
All right.
Hello, sir.
Good morning, ma'am. Can you tell me your name?
Yvonne Vanakis.
Ma'am, you're here in case 2021 MM4143AO on charge of battery domestic violence. Did review the charging affidavit in your case. Did find probable cause for your arrest. Going to set your bond in this case in the amount of, one second. In amount of $1,000. Be subject to pretrial release supervision. You had no contact with the victim in this case. Did not return to the location where this incident happened. You are to maintain a separate residence from this victim. I'll give you a one-time return if you have a shared residence with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You may not possess or consume any drugs or alcohol without a valid prescription. You also be subject to random drug and alcohol testing at your expense. I want to appoint the public defender to represent you in this case, ma'am. You have a great day.
Your Honor, I believe she's from Pennsylvania.
Yeah, I'm sorry, I'm gonna allow you to return back home, but, gotta book a flight, go home. But don't violate my orders while you're in Pennsylvania, because they're gonna put you on a little bus and send you back here. Do you understand that?
Sir.
All right, have a great day.
Your Honor, so the no return to the scene, which was the airport, she's allowed to return if she has a ticket?
That's what I forgot. I forgot what she, I said it was the airport, that's what it was.
Yes.
All right, you're allowed to return to the airport if you have a valid ticket, for no other reason.
Sir.
I've got another World Star. All right, this is Mr. Carr. He's here on, does anybody know if he's downtown on these other cases?
He is, Your Honor.
Which cases?
He, on the 2020 CF 8646 at 9:29, the last note I see is that he was signing a plea, and they wanted to work out a global plea.
Are you gonna work out this case as well?
I don't know about the new case. I just know the two out on bond cases. It was at 9:29 this morning.
Well, I'm gonna have you waive, I'm gonna appoint a public defender to represent him. Can you waive his arraignment and find out they can add on to that case as well?
I have a note from the ASA in that 8646 case. Defendant pled guilty to that felony and resolved with misdemeanor case, the 20 CT 7775. Is this case?
This is 4353.
So those are the two that he's out on bond for.
I'll waive the appearance, Your Honor.
All right, I'm going to state his bonds in this case in amount of $500. Condition of his bond, not allowed to operate a motor vehicle without a valid driver's license. Yeah, no action because the cases are closed. Good morning, sir. Can you tell me your name?
Kevin Jeff Don Joy.
Mr. John Joy, you're here in case 2021 CT 491AA on a failure to appear on a charge of attaching a tag. The judge signing your bond says your bond in the amount of $250. Was that an offer to resolve Mr. Don Joy's case?
Yes, Your Honor. The offer that was conveyed was an adjudication credit time served.
And is he represented by the public defender's office or?
No, Your Honor, but he would like to accept the state's offer.
All right, Mr. Don Joy, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You put your hand down. Sir, you're here in case 2021 CT 491AA on charge of attaching a tag to a vehicle not assigned. That's a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. You understand that? Do you want to enter pleas of guilty or no contest to resolve your case?
No contest.
Do you understand by entering a plea of no contest, you're going to waive all the rights outlined on that plea form that's in front of you?
Yes.
Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation? I did actually have an opportunity to review your court file this morning. The court did find factual basis contained therein. I'm going to accept your plea of no contest. Find your plea is freely and voluntarily entered. I want to adjudicate you guilty of the charge. I'll give you credit for the
2 days.
2 days that you have in the Orange County Jail with 2 days credit time served. The court costs and costs of prosecution in this case are $306. I'll give you 2 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment sentence in writing. I'm not taking any action on your felony case. Have a great day, sir. 2 years. Good morning, sir. Can you tell me your name?
Jonathan Hodges.
Mr. Hodges, you're here in case 2021 CT 262AW for a failure to appear. An online charge, I believe, of driving under no valid driver's license. Judge signed your warrant, says your bond amount of $2,000. State was an offer to resolve this case.
Yes, Your Honor. Withhold credit time served.
Your Honor, he already has his driver's license. He would like to wait and resolve this case, so I would just ask that you set the bond amount.
Does he have a valid driver's license? All right, step back, Mr. Hodges, while the state, looks that up. All right. And Appleton, the next person. Good morning, sir. Can you tell me your name?
Marcus Sean Appleton.
Mr. Appleton, you're here in case 2016 CF 15296AO on a violation of probation. This is on view, I believe, yes. Based on view arrest of the law enforcement officer. Your bond's gonna be set as none in that case. You're a violent felony offender of special concern, sir. You're not gonna be able to be released on your violation of probation until your violation of probation is completed and come to a hearing. You also were arrested in case 2021 CF 7135AO on charges of possession of MDMA or ecstasy and possession of cannabis. You were also arrested in 2021 CT 4355AO on charge of driving while license suspended. I did review those charging affidavits, did find probable cause for your arrest as to those charges. I want to set your bond and count one in the felony case, amount of $1,000 and $100. Condition your bond not to possess any drugs or alcohol without a valid prescription. As to your driver's license suspended case, in 2021 CT 4355AO, I want to set your bond amount of $500. Condition that bond not operate a motor vehicle without a valid driver's license. I'm going to appoint the public defender to represent you in all your cases. You have a great day. All right, Mr. Hodges. All right, Ms. Davis, let me know that Mr. Hodges does have a valid license. So state, what do you want to do with that case? In case 2021 CT 262 AW. Do you want
Well, announce
the,
a null pros, Your Honor.
do you want it? The David?
I pulled it up, Your Honor.
Okay.
It is staying valid.
Second. No, she hasn't yet. I was trying to see if that's what she was about to do.
Yep.
You're announcing a null process?
It's announcing a null pros, Your Honor. I'm filing it with the court as we speak.
All right, Mr. Hodges, the state is dismissed the charges against you. You have a great day, sir.
Could I ask you a question?
I'm going to have you ask Ms. George the question because otherwise everything you tell me is on the record. Good morning, sir. Can you tell me your name?
Michael Flores.
Mr. Flores, you're here in case 2016 CF 8381AO for violation of probation. The judge signed your warrant in your case, set your bond at none. Your bond is going to remain at none in this case. I want to appoint the public defender to represent you in this case. You have a great day, sir. Good morning, sir. Can you tell me your name?
Bashar Hassan, Your Honor.
Mr. Hassan, you're here in case 2013 CT 6338BO for violations of probation. I believe this was another one. The judge signing your warrant in your case set your bond at none. Your bond's going to remain at none, sir. You are a violent felony offender of special concern. You're not going to be entitled to release on bond on this case until your violation of probation is completed. I'm going to appoint the public defender to represent you in this case. You have a great day, sir.
Your Honor, did you get all three?
I'm sorry. You're also here in 6358DO and 6337DO for violation of probation, all set at none. Violent felony offender on all those cases. You're not going to be entitled to release. All right. Have a great day, sir. And he's get a public defender in all those cases. Good morning, sir. Can you tell me your name?
London.
Mr. London, you're here in case 2020 CF 363 AO for violations of probation. The judge signing your warrant in those cases, I believe there's a warrant.
There's one warrant, one on view.
Which I don't know how that happened. Well, yeah, there's a warrant, and I guess the law enforcement officer doubled down and gave you an on-view violation as well. Your bonds in both those cases are set at none. You're also arrested in case 2021 CF 7093AO for violent driver license suspended as habitual traffic offender, possession of MDMA or ecstasy, and possession of drug paraphernalia. As to count one, the court's going to set your bond amount of $2,500. Count two, $1,000, and count three, $100. You're all also arrested in 2021 CT 4356AO on charge of reckless driving. As to that case, the court's going to find probable cause for your arrest, going to set your bond, in that case, the amount of $500. Conditions of bonds in both those cases that you not operate a motor vehicle without a valid driver's license, you may not possess or consume any drugs or alcohol without a valid prescription. I'm going to appoint the public defender to represent you in all your cases. You have a great day, sir. Good morning, sir. Can you tell me your name?
Kevin George Neese.
Mr. Aeneas, you're here in case 2018 CF 17297AO for a violation of probation. The judge signed your warrant in your case to set your bond at none. Your bond's going to remain at none in this case. I'm going to appoint the public defender's office to represent you in this matter. You have a great day, sir.
Thank you.
Your Honor, I believe he also has reporting requirements.
Say again?
He has reporting requirements as well.
Yeah, he's not going anywhere, so. No. It was a guy in Forest too. It's on life probation. Good morning, sir. Can you tell me your name? Mr. Young, you're here in case 2019 CF 3378AO for violations of probation. Based on your on-view arrest by law enforcement, your bond's going to be set at none in that case. You're also arrested in case 2021 CF 7128AO for charges of neglect of a child, possession of a weapon or firearm by convicted felon, possession of drug paraphernalia. Manufacturing of drug paraphernalia, possession of drug paraphernalia, possession of cannabis with intent to sell and deliver. And you're also arrested in 2021 CT 4357AO for driving license suspended. I did review the charging affidavit, did find probable cause for your arrest as to all those charges. As to your felony case 2021 CF 7128AO, as a count one, I'm going to set your bond amount of $10,000 in count one. Count two, $10,000. Count three, $1,000. Count four, $100. Count five, $15,000. Count six, I'm going to ROR you as to that count. And in 2021 CT 4351AO, I'm going to state your bond amount of $500. Condition in all your cases, you're not allowed to possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You have no contact with the alleged victim or child in this case. You have no unsupervised contact with any child under the age of 18 years old. You are to not possess or consume any drugs, alcohol without a valid prescription. You are to not associate with any known drug dealers or drug users. I want to appoint the public defender to represent you in all your cases. You have a great day, sir.
Your Honor, just to be clear, you are awarded as to the possession of the weapon?
Yeah,
Okay,
from what I read it, like they doubled down, so.
okay.
So. Yep. Good morning, sir. Can you tell me your name?
Kirby Almonte.
Mr. LaPonte, you're here from an out-of-county warrant from Polk County in case 2020 CF 1501. The judge in Polk County set your bonds at an amount of $2,000 on each one of your counts, so there are 5 counts. Your bond is going to remain as set until you get over to Polk County. Or you can bond out, or you get over to Polk County. You want to appoint the public defender to represent you in this case.
I already bonded out.
Okay. All right. Make sure you don't miss any court dates out there in Polk County. Have a great day. All right. Good morning, sir. Can you tell me your name?
Jimmy Landers.
Mr. Landers, you're here in case 19 This is a Hillsborough County, out-of-county warrant for charge of possession of controlled substance.
Yes, sir.
The judge in that case set your bond amount of, because of a failure to appear, the judge set your bond amount of $0. We're gonna get you on to Hillsborough County as soon as possible. I'm gonna appoint a public defender to represent you while you're here in my custody. You have a great day, sir. Good morning, ma'am. Can you tell me your name?
Sterling.
Ms. Sterling, you're here for an out-of-county warrant from Jefferson County, I believe in case 2020 CT 76. The judge in Jefferson County set your bond in an amount of $1,000. Your bonds will remain as set. If you're not able to bond out, we'll get you transported to Jefferson County as soon as possible. I'm going to appoint a public defender to represent you while you're here in my custody. You have a great day, ma'am. Good morning, sir. Can you tell me your name?
Favell Williams.
Mr. Williams, you're here in case 2020 MM 3664 for an out-of-county warrant from Seminole County. The judge in Seminole County set your bond amount of $1,500. Additionally, your bonds, you had no contact with the victim in this case. I'm going to appoint the public defender to represent you while you're here in my custody, so you can bond out, or we can get you on to Seminole County as soon as we can.
Right. I got a question, sir.
Yes, sir.
I bonded out on the same charge like a couple months ago, right? But I never received no paperwork talking about any court dates.
I don't know what address you have on record for them. I have 4501 Lake Martin.
Yes, sir.
Is that the address they have out there in Seminole County?
It should be.
You may want to check on that.
All right, sir. Have a good one.
All right, have a great day. Does anybody have anything else for the better of the order?
Nothing else from the state, Your Honor.
Ms. Davis? All right, have a great day.
He is not allowed, no, he. Sorry, I was looking at the wrong one. He is not allowed to possess a weapon of any kind, firearm, or ammunition. He's not allowed to return to this scene for any reason at all.
On his out on bond case, Your Honor, I would have you take no action as he's already going to be held on the punishable by life offense.
Thank you, Counselor, but I'm revoking it at this time. Are there any other conditions the state would request in this case?
No, Your Honor.
All right.
Just to be clear, he refused? Was that?
Behavior.
Behavior, thank you.
Why do these all say Bain? He was never supposed to be in court today. All right. Please tell me your name.
Shayla Davis.
MO 69. You're here charged with violation of state misdemeanors. I'm sorry, 692. There is probable cause in this case. Was there an offer?
Yes, Your Honor, the offer that I've been authorized to give on behalf of the city is a withhold and credit time served.
Mr. Brands, did you discuss that with her?
Yes, with Ms. Davis, I discussed citizenship, probationary issues about entering a plea, and Ms. Davis would like to enter a plea today.
Please raise your right hand to be sworn.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes. All right, you heard what Mr. Brands just told the court. Is that what you want to do here today?
Yes, that is.
And you understand the rights you're giving up by entering a plea?
Yes, I do.
Do you have any questions for me about those rights?
I don't.
Is that the plea form in front of her?
Yes, Your Honor.
All right, Ms. Davis, I want you to take a look at that plea form and tell me if you understand that and if you have any questions about it. You understand?
I do.
All right, and you understand that if you're on probation, this will violate that. And if you're not a U.S. citizen, you could be deported. You understand that?
I understand it.
Has anyone threatened you or promised you anything in order to get you to enter this plea other than the state's offer?
No.
All right, at this time, how do you wish to plead to the charge of violating state misdemeanors?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in jail. I have to order that you pay court costs, and I'll give you a year to pay those. Do you understand?
I do.
All right, good luck, ma'am. You have 30 days to appeal in writing.
Thank you.
I spoke to Ms. Davis as a friend of the court, Your Honor.
Yes, I did not appoint the PD. To what? All right, who's next? Is that him? Is that who's next? Teleconference? This is Judge Gibson. Who do I have on the line?
My name is Clotilde Zomon, Clotilde, interpreter ID 113116 for Haitian Creole.
Good afternoon. Has the interpreter been sworn today?
Not yet.
Please raise your right hand to be sworn.
Okay.
Do you swear to translate from Creole to English, English to Creole truthfully in these matters here today?
Yes, I do.
All right. Sir, please tell me your name.
Monsieur, s'il vous plaît, ba-moi nom.
Sadrack King Honora.
Sadrack Honora.
21 MM 4138. You're here charged with trespass on property after warning and resisting an officer without violence.
Oui, mon cas là, c'est 21 MM 4131 et que yo ou te dans une propriété côté que un officier qui te gagne pour t'arrêter ou pas te résister sans que ou pas te faire ça. D'accord?
There is probable cause in this case.
Probablement qu'on a une cause dans cas là
Did the state have an offer?
et que état gagne un faire un off.
Yes, Your Honor. The offer that was conveyed was an adjudication of guilt, credit for time served, and no return to the property located at 5265 South John Young Parkway.
Oui. Oui, juge et que pour que gagne un affaire de faute, côté que il pas retourner dans la propriété encore qui localisé dans 5265 John Young Parkway.
Mr. Brantz, were you able to discuss that with Mr. Honorat?
Not at length, Your Honor, due to the language barrier.
Même pas capable un juge à cause de barrière de langage.
But let me remind Mr. Honorat that if he is not a citizen or if he's on probation, entering a plea may deport him or violate his probation.
Je voulais faire monsieur Honora connaître que si son monde qui pas citoyen tel boy ici, il pas légal boy ici, il capable de sujet à déporter que si gagne une violation qui est capable faire dans cas.
And I also advise Mr. Honorat to look at the rights that he would waive by entering a plea on the English plea form. If he has trouble reading that, please let me know.
Et puis, je vais faire comme monsieur Honora connaît que je vais aviser tous ou deux pour capable rentrer dans place ça, soit en octobre ou pas en octobre et que si capable lire anglais, dis-moi, fais me connaître. Yes, I can read it.
And if you wish to enter a plea today, Mr. Honorat, you can enter a plea of no contest.
Or guilty.
Et puis, monsieur Honora, si toutefois que tu as voulu rentrer en plein, ou tu es capable de dire que ou pas contester, ou bien que ou capable de dire que ou pas en tort non plus. Not guilty.
All right. Mr. Honorat, at this time, I'm going to appoint the Public Defender's Office to represent you in this case.
Monsieur Honora, sur ce point, je peux aller appointer un public défenseur pour capable de dans cas là. Vous entendez?
Oui.
Sir, your bond is $500 on count one, $100 on count two.
Bon, monsieur, je voulais reconnaître que, bon, donc, c'est $500 avec $100 pour compter sur ça.
You are not allowed to return to the Publix located at 5265 South John Young Parkway. Do you understand?
Ou pas gen droit pour capable retourner dans le public ça encore, qui localisé dans 5265 John Young Parkway. Est-ce que vous comprenez ça?
Oui, je comprends.
Yes, I understand.
All right, good luck, sir.
Bon, merci beaucoup, monsieur. Bonne chance.
Okay.
Okay, thank you.
Are there any other
Anything
Creole
else I can
cases?
assist you on?
No, Your Honor.
That's all for the interpreter at this time. Thank you.
Thank you.
I hit it too fast. I didn't mean to hit. Well, that's what it is then. All right, 20 CF 6789. It's a capias, Mr. Brands. I'm going to appoint your office to represent him.
We'll waive the appearance at this time, Your Honor.
All right, I'll stay the bonds. It's $2,000 on count one and $500 on count two.
Thank you, Your Honor.
Please tell me your name.
Jonathan Fry, Jr.
Thank you. You're here in 21 CF 7143, charged with burglary of an occupied structure, grand theft, and resisting an officer without violence. I'm going to appoint the Public Defender's Office to represent you. I reviewed the probable cause affidavit in this case. I do find there's probable cause for your arrest. I'll stay your bonds at $500 on count one, $500 on count two, and I'll reduce count three.
Your Honor, count one is 5,000. Are you reducing?
Did I say 500? No, 5,000. Yes.
I have a hearing problem.
Oh, you can't
Your
hear me?
Honor, I'm so sorry.
No,
Both
it's
of my
okay.
ears, so.
It's okay. We need to make sure you hear me.
Yes, exactly.
Does this help?
Yes, this one. Thank you. Sorry. Okay.
All right, did you hear anything I said?
Not really. That's why I asked for the headphones. I'm so sorry.
I'm glad you did. You don't have to apologize. I want to be sure that you understand what we're doing.
I understand.
So you're charged with burglary of an occupied structure, grand theft, and resisting an officer without violence. I'm appointing the Public Defender's Office to represent you.
Okay.
I do find probable cause.
Yes.
I'll stay your bond at $5,000 on count one, $500 on count two. I'll reduce count three to $100.
Okay.
You are not allowed to return to, is it the 7-Eleven?
Yes, Your Honor.
Do you have the, here it is, 1 North Rosalind Avenue. Do you know where that is?
I'm sorry. Say that one more time, Miss, Your Honor.
The 7-Eleven?
Yes, the 7-Eleven I went to. I
Okay,
would
you know not to go back there.
Ever.
You can't have any contact with any victim or witness in this case.
Understood.
You understand? You can't possess a weapon, firearm, or ammunition. Do you understand?
Understand.
Are there any other conditions the state would request?
No, Your Honor.
All right, do you understand?
I understand. So that's my, this is my bond?
5,000 plus 500 plus 100 is your bond.
Okay. Okay.
You understand? You have any questions?
That was my question, really. I just wanted to know if I had a bond.
Yes, you do.
I gotta add it up. So 10% of everything, right?
It's $3,600.
$3,600?
I mean 50, what did I say?
5,600.
It's $5,600, $5,600.
$5,600. 10% of that is.
That's between you and a bondsman.
That's what? I'm sorry.
That's between you and a bondsman.
Okay.
I don't have anything to do with that.
I understand. Okay. Thank you.
All right, good luck, sir.
Rachel Hall refused court, Your Honor.
21 CF 7100. I find her refusal a willing waiver of her appearance today. There is probable cause. I'll appoint the Public Defender's Office. I'll stay the bonds as listed, 1,000 on count one, 150 on count two, 100 on count three. She's not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Please tell me your name.
Demarge Pearson.
You're here because a warrant was issued for your arrest in 21 CF 6864, charging you with first-degree murder. Another judge has already found probable cause in this case. I'll appoint the Public Defender's Office to represent you.
Your
Ms.
Honor.
May?
Your Honor, before you appoint us, I believe we would have a conflict. We represent a co-defendant, so if you would appoint the Regional Conflict Counsel in lieu of our appointment.
Your Honor, respectfully, you can't do that. You have to appoint the.
Right, I think I appoint the Public Defender's Office and then you conflict off, and that's how they get Regional Conflict Counsel. Go ahead, Ms. May.
In regards to the only count, it is a punishable by life offense. State is asking that you hold him no bond pending an Arthur hearing.
No argument, Your Honor, pending that Arthur hearing downtown with his attorney.
I will do that, sir. You have no bond on this charge, but even while you're in custody, I'm ordering that you're not allowed to have any contact with the victim's family. Do you understand?
Yes, ma'am.
All right.
Your Honor, state would also ask for no contact with the co-defendants and what.
You're also not allowed to have any contact with the co-defendants. Do you have their names handy so we can tell corrections?
There were several, Your Honor. I believe this is the warrant where they wouldn't disclose witnesses' names due to possible retaliation.
With the co-defendants?
Regarding co-defendants, I have Keontae Dortch.
If you give it, that way he can make sure they're not in the same area.
I have an inmate number if that's easier.
We can move forward, Your Honor.
All right, we'll get those names and they'll make sure that you're not in the same area here. Good luck, sir. Ma'am, please tell me your name.
Marshea Bills.
You're here in 21 MM 4158, charged with prostitution or lewdness. I reviewed the probable cause affidavit. There is probable cause in this case. I'll appoint the Public Defender's Office to represent you.
Your Honor, considering the lack of criminal history, would you consider ROR? If not further, I think the arrest affidavit is inconsistent with these charges. We have a few charged with the same crime, and some of them are, the bond suggestion was 1,000, while others are 500. I would have you consider that in interest of equity. I don't know what why there's a difference in that. I couldn't figure it out, but I believe most of them were at $500 bond, while I think this Ms. Beals and another in this section were set at 1,000 as the suggestion. I would just have you keep it consistent across all these cases.
Counselor, I don't know what the arresting officers are thinking.
Your Honor, she does have a prior arrest for prostitution, however.
It says there's a prior failure to appear on that.
Yes, Your Honor.
When was that? The
I don't
failure to
believe-
appear?
I don't believe it's in Orange County.
Oh, so we don't know?
No, Your Honor.
I believe if you issue a monetary bond, that should be sufficient to produce the client at any future court dates.
All right, ma'am, your bond is $500. You can't return to the intersection of La Quinta Drive and South Orange Blossom Trail. Do you know where that is?
Yes, ma'am.
Don't go back there, okay?
Yes, ma'am.
What? Yeah, I did. Hold on. Are there any other conditions the state would request?
No, Your Honor. I believe the no return to the actual scene is better than the mapping area at this point.
All right, good luck. Yes, ma'am.
So I just have to call and get an attorney and get that figured out with them?
What?
My bond?
Your bond? You can call the attorney and ask them, but I think you'll have to work that out with, they can give you advice about that, yes. Yes, ma'am, good luck.
Ennis Medical.
21MM4149, it's a trespass, Counselor. Do you want to waive his appearance?
Yes, Your Honor. There is an offer from the state, but I haven't had a chance to speak with Mr. Dennis. But we'll waive his appearance for now. I know you're not keen to reset anything till tomorrow because of our larger docket tomorrow. I'll be here with you as well, so.
He won't, because of what it is, he won't be available for probably 10 days.
I understand.
So I don't want to, I'd rather do the hearing so he at least can get out if he wants to.
If appointed, our attorney can work with him downtown on an offer as well to resolve this case.
Unless the state has any reason not to, is there a reason I shouldn't release him on his own recognizance?
Your Honor, other than the fact that he just pled to another trespass, I'm not sure where that one is.
But that's all the history I'm seeing.
Yes, Your Honor. So
I'm going to release him on his own recognizance, no contact with the co-defendant, and no return to 605 West Colonial Drive, that 7-Eleven.
Thank you, Your Honor.
Yes, sir. That's the co-defendant, 21MM4150. There is probable cause. I'll appoint your office.
We'll waive the appearance, and in the interest of equity, I would have you release Ms. Fouch on ROR as well.
I will, with all the same conditions, no contact with the co-defendant, no return.
Thank you, Your Honor.
John Hendricks, his behavior.
21MM4148, there's probable cause here for a trespass. Counselor, do you want to waive his appearance?
We'll waive the appearance, yes, Your Honor. There's also an offer from the state on this case as well.
I don't know what that is. I don't have the volume high.
That might be me. I'm trying to move my phone away from it.
I don't have my phone near it. He has a much more extensive criminal history, so I'm not inclined to release him on his own recognizance.
I believe the $500 bond is sufficient, Your Honor.
All right, I'll stay the bond at $500, no return. Please tell me your name.
Asia Hill.
You're here in 21MM4159. Charged with prostitution. There is probable cause, and I'll appoint the Public Defender's Office to represent you. Your bond is $500. You're not allowed to return to the intersection at 43rd Street and South Orange Blossom Trail. You know where that is?
Yes.
Don't go back there, okay? Do you understand?
Yes.
Do you have any questions?
Yeah, I'm trying to ask. This is my first offense. I've never been arrested or anything. I'm trying to get my own recognizance. I have to be set up for dialysis with Florida Health, and I have never been arrested.
Your Honor, I have a lengthy out-of-state history.
How long have you been here in Florida?
About almost 6 months.
Yeah, I show a lengthy out-of-state record, but I don't show any Florida convictions.
Yeah, I don't have none at all, and I have to have dialysis. I think that I'm hemorrhaging now.
Does the state have any objection?
Your Honor, her out-of-state history is slightly violent, so the state would object to an ROR.
I'm going to release you on your own recognizance
Thank you.
with the same condition. Ma'am, don't make me regret this, okay?
Thank you.
Good luck.
Thank you. Thank you.
Please tell me your name.
Kennedy.
21MM368, you're here charged with trespass on property after warning. There is probable cause in this case. Was there an offer?
Yes, Your Honor, the offer that I conveyed was an adjudication credit time served and no return to the gas and go.
Your Honor, I did speak with Mr. Kennedy in the back, and we spoke about the state's offer as well as the citizenship and probationary issues of entering a plea. Also about the rights that would be waived as a result of entering a plea, and I believe Mr. Kennedy would still like to enter a plea today.
Please raise your right hand to be sworn.
Yes.
All right, Mr. Kennedy, you heard what Mr. Brands just said. Is that what you want to do here today? Did you? I'm sorry, I couldn't hear you.
Yes.
Thank you. And you understand the rights you're giving up if you enter a plea of guilty or no contest, right?
Yes.
You understand if you're not a U.S. citizen, this plea could deport you.
Yes.
And you understand if you're on probation anywhere, this plea could violate that.
Yes.
Has anyone threatened you or promised you anything to get you to enter this plea?
No, ma'am.
Does he have another open case for which he's out on bond? It says that on the face sheet, but I don't know if that's accurate. 2019 MM 3889.
Yes, Your Honor. It is a battery. He had supposedly had arraignment on it June 12th.
So he's out on bond on that charge?
Yes, Your Honor. I don't know if he has bond or if it was a PTR or ROR.
It's from 2018. It was a non-arrest. It was filed.
Okay, so he's not out on bond.
No, he was never arrested on it.
The reason I'm asking these questions is if you're out on bond and you get arrested for a new charge or you plead to a charge, we could revoke that bond, and I just didn't want that to happen and you be surprised. I wanted to be sure before you enter a plea, you know exactly what's happening.
Right, right.
Okay, so it doesn't look like that's a problem for now. All right, sir, at this time, how do you wish to plead to the charge of trespass on property after warning?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for the 2 days that you've been in jail. I have to order that you pay court costs. I'll give you a year to pay those. And I'll further order that you're not allowed to return to
The Gas and Go, Your Honor.
Gas and Go. Do you know where that is?
Yes.
On West Colonial Drive?
Yes.
Okay, you can't go back there. You understand?
Yes, ma'am.
All right, good luck, sir. You have 30 days to appeal in writing.
I spoke with Mr. Kennedy as a friend of the court, Your Honor.
Yes, I did not appoint you.
See.
Thank you. Please tell me your name.
Daisha,
Daisha what?
Daisha Marr.
21MM4160, you're here charged with prostitution. There is probable cause in this case, and I'll appoint the Public Defender's Office to represent you.
Your Honor, looking at the criminal history as well as considering her plans to return to California, when you issue bond, if you could also allow her to return to California, she'll stay in contact with our office to address any future court dates, work with her attorney on that.
Your bond is $500. I will allow you to return to California, but you understand you still have to come back to answer for this charge, right?
Yeah.
Stay in touch with your attorney. You're not allowed to return to Burlington Coat Factory on Orange Blossom Trail. You know where that is?
Yes, ma'am.
All right, good luck.
Thank you.
Please tell me your name.
Yes, Matthew Purley.
21MM4140. You're here charged with trespass in structure or conveyance. There is probable cause in this case. Is there an offer?
Not at this time, Your Honor.
I'm going to appoint the Public Defender's Office to represent you. Your bond is $500. You're not allowed to return to Do you have it, Counselor?
6698 Corsica Court.
You know where that is?
Yes, I do.
Okay, you can't go back there. You understand that?
I do.
I show that you're also out on bond. At this time, I'm inclined to revoke that unless you can give me a reason not to, Counselor.
He is working with our office to resolve that downtown at this time. He is transient, I believe. He has homelessness issues. Considering the nonviolence of the current charge as well as the nonviolence of the out on bond cases and his cooperation with our office, I would have you consider no action or at least a higher monetary bond to really hammer the point home that Mr. Purley should avoid new law violations while out on bond.
I'm going to take no action on that case, but in this present case, the trespass, I'm also ordering that you can't have any contact with any victim, witness, or co-defendant in the case. Do you understand that?
I understand.
Okay, good luck, sir.
Your Honor, in the out on bond, we haven't even filed on it yet.
Okay. I'm not taking any action. Sorry, I added that. Did you hear that? No contact, right? Please tell me your name.
Evelyn Selena Redden.
Ma'am, you're here in 21 MM 4162, charged with prostitution. There is probable cause in this case. I'll appoint the Public Defender's Office to represent you. Your bond is $500. You're not allowed to return to the intersection at Conley Street and South Orange Blossom Trail. You know where that is?
Yes, ma'am.
All right, don't go back there.
All right.
You understand?
Yes, ma'am.
Okay, good luck.
I thought maybe I'll go get sentenced today.
Wait, I couldn't hear you, what?
I thought maybe I'll go settle this and get sentenced today.
Oh, this is not a kind of charge that I can accept a plea on today.
Okay.
Because of the type of charge, there's some things that your attorney is going to have to do with the state. Sorry, good luck. Please tell me your name.
Nicole Simpson.
21 MM 4163, you're here charged with prostitution. There is probable cause, and I'll appoint the Public Defender's Office to represent you. Your bond is $500. You're not allowed to return to La Quinta Drive and South Orange Blossom Trail. You know where that is?
Yes.
Okay, don't go back there. Counselor, your client is out on bond. I'm inclined to revoke that unless you can give me a reason not to.
I understand, Your Honor, however, the out on bond cases as well as the current charge are both nonviolent. It's a trespass on property as well as a possession of cannabis, not the kind of serious charges or violent charges that would justify keeping someone in custody for an indefinite amount of time. I would just have you take no action or at the very least set a higher monetary bond to hammer that point home that Ms. Simpson needs to avoid new law violations while out on bond. She also has a very thin criminal history, especially here in Florida. I would have you consider that as well.
I will. At this time, I'm going to take no action on that case. Good luck, ma'am.
Does that mean I get to get bond?
Right, I didn't revoke your bond. Yes, so you still have bond. Yes, ma'am. $500. Good luck.
Ms. Smith, bonded. Ms. Stallings, bonded. Walter Stevenson, bonded.
Please tell me your name.
Person Madewell.
21 MM 2762. Sir, you're here because a capias was issued for your arrest for failing to appear for arraignment on a charge of petty theft of $100 or more. The bond is $2,000 on that capias.
Your Honor, there was an offer conveyed, an adjudication, credit time served, no return to Walmart, and cost of investigation to Orlando Police Department in the amount of $77.42.
42.
42.
Your Honor, I did have a chance to speak with Mr. Madewell in the back, talked about the results of entering a plea today, the rights that would be waived, the citizenship and probationary issues, as well as the enhanceability of pleading to a petty theft charge. And we discussed all of that. Mr. Madewell would still like to enter a plea today.
Please raise your right hand. All right, Mr. Madewell, you heard what Mr. Branch just said. Is that what you want to do here today? You understand all the rights you're giving up by doing this? Do you have any questions for me about those rights? And you understand if you're on probation, this plea will violate that? And if you're not a U.S. citizen, this plea could deport you?
Yes, ma'am.
Has anyone threatened you or promised you anything to get you to enter the plea?
No, ma'am.
All right, at this time, how do you wish to plead to the charge of petty theft of $100 or more? Hold on, before you answer that, let me ask you one more question. Did Mr. Brands have an opportunity to explain to you that petty theft is an enhanceable offense? You understand what that means? After so many convictions, the state can charge this as a felony. And a third-degree felony is punishable by up to 5 years in prison. So you understand that? All right, at this time, how do you wish to plead to the charge of petty theft of $100 or more?
No contest.
I'll accept your plea of no contest. I find it's freely and voluntarily made. I'll adjudicate you guilty, give you credit for
14 days.
14 days that you've been in jail. I have to order that you pay court costs. I'll give you a year to pay that. I'm also going to order that you pay $77.42
OPD.
to the Orlando Police Department for the cost of investigation, and that you're not allowed to return to
Walmart, Your Honor.
Walmart. You understand? Do you have any questions for me? All right, good luck, sir. You have 30 days to appeal in writing.
And I spoke with Mr. Madewell as a friend of the court, Your Honor.
Yes.
Also, may I approach, Your Honor?
Oh, he already had the PD appointed, so
That's right. So,
he'll have to pay that too.
spoke to him as an attorney that we're assigned.
Yeah.
Okay, can we approach, Your Honor?
Yes.
I have
Killing me. Please tell me your name.
Pedro Rivera Acosta, ma'am.
One more time.
Pedro Rivera Acosta.
Yes. A capias was issued for your arrest in 21 MM 1388, charging, because you failed to appear for arraignment on a charge of petty theft with a prior conviction. The bond on that is $500. Was the PD already appointed?
Excuse me, ma'am. I was in the quarantine dorm.
Oh, get closer to the microphone.
I was in the quarantine dorm.
You were,
I was already.
oh, you were in custody? Okay, so let me explain. Because this is a capias that was issued by another judge, I can't change it. But you have the public defender representing you. What they can do is file a motion to quash it with the court and show the court who signed this capias that you were in custody. So it would have been up to the state to transport you, or because of COVID, they were unable to. But only that judge can do it. I can't. So I believe you, but we'll have the public defender file that motion, okay? I have to, yeah. Good luck.
Did you have a bond on that case? For Ms. Warner?
It's a battery.
Yeah, I had it as 0. Okay, interesting.
I said that she bonded to.
The judge who signed the warrant put a bond of $1,000 on the warrant.
Interesting, okay.
Please tell me your name again.
Ibrahim Wilson.
A capias was issued for your arrest in 20 MM 7748 for failing to appear for a pretrial conference on a petty theft charge. The bond authorized on that is $500. And I'll appoint the public defender's office to represent you. Good luck, Mr. Wilson.
Would I be able to?
Just a moment, Your Honor. Let me look at his case file real quick.
Okay. He has another open case, it looks like.
He has a possession.
CF, right. I don't have that one today.
I believe he was seen on it on the 7th.
Did he bond out?
He has a bond of $1,000. I don't know if he bonded. And then
So
he
he
has a
didn't.
bond on this one of 500.
So you didn't bond out? So this capias was for failing to appear for a pretrial on 6/14. So you were here.
He does have a private attorney. Hold on.
Oh, he has a private attorney?
That's wrong, sorry.
Oh,
Caleb Robinson as my public defender.
okay. Do you know which judge you saw? What's Division 82?
Dubois.
But the officer that came in the cell yesterday told me that when I come today, just let you guys know that I was already in custody since the 7th.
I believe you, and I'm sure we can verify that, but because this is another judge's capias, I can't change it. However,
Your Honor, I also have a capias from 5/3, and then it was set for pretrial on 6/14, and then he didn't appear for that. So I believe there was a capias, they set a pretrial, and then he didn't appear because it appears he was in custody. So it's technically 2 capiases,
What date was the capias, the one you're mentioning now?
5/3.
no, the only one I have right now is for failing to appear for pretrial on 6/14.
Was there an order quashing that capias on 5/21 by chance? So we have a motion to quash. I don't know if there was an order.
I'm going to go off the record for one moment.
There is a motion to quash. Do you want me to stop talking?
Give me 1 minute. All right, Mr. Wilson, here's what I'd like to do. I'd like to recall you at the end of the docket. I'm going to try to get in touch with your trial judge because I saw the same thing that you're saying. So if I can get in touch with the trial judge, maybe we can do something different with your case, but I was unsuccessful. So I'm going to try that. We'll call you back in a little while.
Would I be able to,
Get close to the microphone.
would I be able to, get a global with the possession that I have now?
A what?
Global, please?
Oh, a global plea agreement. I'll ask the state about that. The court doesn't do that. That's up to the state. I don't know.
Not this time, Your Honor, 'cause
But it wouldn't be today anyway. I can't accept a plea from you today on that. But we'll recall you in just a few minutes. As I throw my phone. All right, let's see if we can get that done. Please tell me your name.
Michael Blackman.
A warrant was issued for your arrest for violating your probation in 20 CT 5678 by committing the offense of possession of cocaine and resisting an officer without violence and failing to pay $50 per month. There is no bond authorized on that, and I'll appoint the Public Defender's Office to represent you. What? Oh, do you want to enter a denial, Mr. Brands?
Yes, Your Honor, we'll enter a denial on the violation.
Division 80 VOP status, July 23rd at 9 a.m. and 9 p.m.
Please tell me your name.
Malvin Troche Cruz.
21 MO 691, you're here charged with open container of an alcoholic beverage. There is probable cause. Was there an offer?
yes, Your Honor, I've been authorized on the city's behalf to offer a withhold and credit time served.
Can I have a moment to confer, Your Honor?
Yes.
I had a chance to speak with Mr. Cruz about the state's offer. I believe he wishes to enter in a plea. We spoke about citizenship probationary issues as a result of entering that plea and the rights that would be waived as well.
All right, Mr. Cruz, raise your right hand.
You swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you put your hand down. You heard what Mr. Brands just said. Is that what you want to do here today?
Yes, ma'am.
You understand all the rights you're giving up if you enter a plea of guilty or no contest?
Yes, ma'am.
Do you have any questions for me about those rights?
No, ma'am.
And you understand if you're on probation, this plea could violate that.
I understand that.
And if you're not a U.S. citizen, this plea could deport you.
I understand that.
Has anyone threatened you or promised you anything to get you to enter this plea?
No, ma'am.
All right, at this time, how do you wish to plead an open container of an alcoholic beverage?
No contest.
I'll accept your plea. I find it's freely and voluntarily made. I'll withhold adjudication, give you credit for the 2 days that you've been in jail. I have to order that you pay court costs. I'll give you a year to pay it. Do you understand, sir?
Yes, ma'am.
All right, good luck, sir. You have 30 days to appeal in writing.
Andrews is a refusal.
21 CF 7137, There is probable cause in this case. I find his refusal a willing waiver of his appearance today.
You're
I'll
up.
appoint the public defender's office. Yes, sir.
On the possession of cocaine with intent to sell, did you find PCS to the amount enough to justify a charge of intent to sell? There's case law that suggests even more than what he had didn't meet the probable cause threshold of an intent to sell charge. It was a very small amount. I think it was 2 separate crystals or cocaine rocks. Also, there was no cash found on him. I don't believe there were any scales or anything like that. So I just didn't see the evidence to suggest that there was an intent to sell the cocaine.
Your Honor, the officer's affidavit says he witnessed Andrews making several transactions with several subjects. I would believe that suggests that there is an intent to sell.
I think that went to the MDMA. I believe that evidence went to MDMA with intent to sell. I'm challenging.
Wait, say that one more time.
I believe that evidence, the transactional evidence, goes to the MDMA, not the cocaine. Cocaine was found in a fanny pack, I think.
You're on the second page where the officer lists the cocaine within 1,000 feet of the business with intent to sell. He said he witnessed him make several transactions.
But he kept returning to this palm tree or palm bush, and it was MDMA that they found in the palm.
But it does say, Andrews claimed a bag and all of its contents. Inside the bag were .77 and .6 grams of suspected cocaine. I witnessed Andrew making several transactions with several subjects. This occurred within 1,000 feet of 3000 West Colonial Drive, which is a 7-Eleven.
And he had possession of the bag while he was making said transactions.
My argument, Your Honor, is the cocaine found in the backpack was with him at the bus stop as he went back and forth, allegedly, to the Palm Branch where they found MDMA. The cocaine was in his backpack, so I didn't see any evidence of transactional evidence to the cocaine. And I fear...
Counselor, it says in the probable cause affidavit, I witnessed Andrews making several transactions with several subjects. So I'm going to find that there's probable cause for both. However, you can always challenge that at a later time if you don't think there's sufficient evidence. But this court finds there's enough cause to believe he probably did. I'll stay his bond at $10,000 on count 1, $150 on counts 2, 3, and 4, and $100 on count 5. He's not allowed to possess or consume controlled substances, have contact with known drug dealers, return to this area. He's not allowed to possess a weapon of any kind, firearm, or ammunition. Any other conditions the state would request?
No, Your Honor.
All right. Wait, give me that back, please. That's not, I don't have the with intent. Okay, yeah. So I'm sorry, it's 10,000 on count 1, 15,000 on count 2, then 150, 150, and 100. Yeah, we got to get that right. Thank you.
I believe you can charge 150 as a subsidiary.
I can, but I'm not going to because of what it is. Please tell me your name.
Dewan Vance Bentley.
21 CF 7064. You're here because a warrant was issued for your arrest, charging you with murder. Another judge has already found probable cause in this case. At this time, I'll appoint the public defender's office to represent you. Ms. May, did you wish to be heard?
Yes, Your Honor. In regards to the charge, it is a punishable by life offense. State is asking that you hold him no bond pending an Arthur hearing.
No argument pending the Arthur hearing downtown, Your Honor.
I can't hear you. What?
No argument, Your Honor, pending that Arthur hearing.
I will at this time hold you at no bond, but even while you're in custody, you're not allowed to have any contact with the victim's family members or with any co-defendants in the case. Do you understand that?
Yes, ma'am.
All right, good luck, sir. Oh, I'm also revoking his out on bond case. Good luck.
Dexter, would you like the co-defendants on this one? they've been arrested.
Please tell me your name.
Shonda Blake.
All right, Ms. Blake. You're here in 21 CF 7146, charged with prostitution, a third or subsequent violation. I reviewed the probable cause affidavit. There is probable cause in this case. I'll appoint the public defender's office to represent you. Your bond is $1,000. You're not allowed to return to Miller Ave and Nashville Ave. Do you know where that is?
Yes, ma'am.
Is there something wrong?
No, ma'am.
Are you okay?
I'm in pain.
What's wrong?
Yeah, I got bit by a pit bull.
I see. I'll ask them if they'll send her to medical to address that, but I just need to make sure that while you're here, you're able to understand what we're doing.
I don't know.
You don't know if you're able to understand me?
No.
All right, Mr. Brantz? Do you want to, how does this work? Do we take her to the medical? He can waive the rest of her appearance. What? Oh, she has? And they released her? Okay. Can they send her back? All right, let's send her back. All right, Ms. Blake,
She'd be screened for mental health assistance while she's here.
I don't know that she qualifies for anything. I can't put her on pretrial release. And I don't know that we have the pretrial, mental health pretrial diversion. I don't know if this qualifies. Does anyone know?
I did speak with her.
I'm not sure for the charge, but you can have her screened. Most likely, she's not gonna qualify, Your Honor.
I did speak with her. She has medication that she does need to be taking. She's been taking all her life, she said, mental health medication.
Your Honor, she's also out on bond on 4 cases, and I don't believe there's any indication of comp concerns in any of those.
Right, I don't see any notes about that,
No, Your Honor.
but I was inclined to revoke those. However, at this time, I think I will not. So I'll take no action on our out on bond cases.
Thank you, Your Honor. And due to the circumstances as well, Social Security disability for 20-plus years, I think the bond is sufficient. And I've spoken with her, and she'll be going home to take the medicine she needs to take.
All right, and I've asked the corrections officers to send her back to medical. All right, good luck, ma'am. Stay in touch with your attorney. Just keeping your paper clips, I don't. Please tell me your name.
Larry Brown.
21 CF 7102, you're here charged with burglary of a structure. Yes, Miss May?
Your Honor, count 1 is actually a life offense.
That's in the other case?
Oh, I'm sorry. Yes, Your Honor.
All right, let's address this one first, and then we'll get to that one. In the burglary of a structure case, there is probable cause. I'll appoint the public defender's office to represent you. Your bond is $3,500. You can't return to the Family Dollar. Do you understand that? You have to answer out loud. You can't have contact with any victim or witness in this case, and you can't possess a weapon of any kind, firearm, or ammunition. As to 21 CF 7103,
Your Honor, could it be heard on the charge of resisting officer with violence?
yes, but first let me tell him what he's charged with.
Yes, Your Honor.
You're charged with burglary of a structure with damage greater than $1,000, resisting an officer with violence, criminal mischief greater than $1,000, and petty theft. Let's hear your argument first, Mr. Brands, and then I'll get to Ms. May.
I don't believe any facts suggested that there was violence against the officer. He did run away. Facts suggest he did run away, but the elements of resisting an officer with violence does require an offering or doing of violence to the person, and I didn't see any facts suggesting that.
State has no objection, Your Honor. I don't believe there's ever any contact with the officer, just flight. So state has no objection to PC just for resisting without.
All right, and what is the state's other argument that you wanted to make?
Your Honor, count 1 is a life offense. I understand arguably it's on the lower end of the seriousness of life offenses and PBL offenses. However, it is a life offense that the legislator dictated as a life offense. So state would be asking for no bond. I understand if you're otherwise not inclined to do so, but would ask for a much higher bond than the 5,000, given that it is a life offense.
Because it is, I will hold him at no bond on that offense.
Well, you have to find presumption, proof
Evident, presumption great.
Your Honor, because if the arrest affidavit even suggested $5,000 and the bond schedule suggested $5,000, I don't see why, because it's towing the line of a punishable by life offense, that we should hold him here at no bond.
The statute doesn't toe the line. Let's look up the law.
And the bond schedule does not suggest $5,000. That's what the officer inputted because he doesn't know.
Nor is the court bound by a bond schedule or a law enforcement officer. The court is bound by the law. So let's read the law together. All right, so 81002 sub 2 sub C sub 2 dash 1. Burglary is a felony of the first degree punishable by imprisonment for a term of years not exceeding life imprisonment if in the course of committing the offense, the offender makes an assault or battery upon any person, or is armed or becomes armed, enters an occupied or unoccupied dwelling or structure and uses a motor vehicle or causes damage to the dwelling or structure or to property within the dwelling or structure in excess of $1,000. So that's what we have here.
Do you find proof evident presumption great, Your Honor?
I do, after reviewing the probable cause affidavit.
I still feel he's entitled to a full evidentiary hearing downtown with his attorney to address those issues.
Respectfully, this is not a court of feelings, Mr. Brands, it's a court of law, so you'll have to take that up with the trial court downtown. They may disagree with you on how the appellate courts have ruled about that. But this court did a full review of the probable cause affidavit, and I do find proof evident and presumption is great, that your client committed a burglary of a structure with damage greater than $1,000.
And you did find probable cause for a resisting officer without violence, Your Honor?
I didn't yet, but I will do that. No, I'm finding PC resisting without violence. What's the statute, Counselor? 843?
843-02.
02. Because count one, you're being held at no bond, I'll let the trial court deal with bond conditions, except I'll just say that you're not allowed to return to that scene. Good luck, sir.
Your Honor, just to be clear, since Mr. Brands wanted you to find proof evident presumption great, was an Arthur hearing held here today or not?
No, we're not having an Arthur hearing, but I found proof evident presumption great without one.
Okay, and you're staying the other 3 bonds?
Yes.
Thank you.
Your Honor, the Arthur hearing is a full evidentiary hearing to determine whether that no bond status can be reset. I'm not prepared to do a full evidentiary hearing here today.
I understand.
My client is entitled to one downtown on the case law.
So the appellate courts are split on their opinions on that issue. So you'll have to argue in front of the trial judge, and the trial judge will make the determination which side of the appellate courts they follow.
I understand, Your Honor.
All right, good luck, sir. Please tell me your name.
Brandon Clayton.
21 CF 7058. A warrant was issued for your arrest, charging you with lewd or lascivious battery, attempted sexual battery with force with a firearm, and kidnapping with a firearm. Another judge has already found probable cause in this case, and I'll appoint the Public Defender's Office to represent you. Yes, Ms. May?
Your Honor, as to count 3, it is a punishable by life offense. State is asking that you hold him no bond pending an Arthur hearing.
No argument, Your Honor, pending the Arthur hearing.
I will do that. At this time, you'll have no bond on count 3.
Your Honor, count 2 as well, I believe potentially is a life offense.
I was about to ask because you didn't say that, but I would think the firearm makes it.
I believe the 794-011 sub 3 is a life offense. However, the attempt, I think, knocks it down, and then I believe the firearm knocks it back up. So I wasn't 100% sure. I am 100% sure on count 3. But given that he will be held no bond, and I'm not entirely certain as to count 2, given the attempt and the firearm.
Right, because the attempt brings it down 1, but the firearm brings it up 1.
So I'm pretty positive, however, I don't want to misrepresent to the court.
All right, let's look it up.
Excuse me, Judge.
Yes, sir.
I've been here 14 months.
Hold on, I can't hear you. Get close to the mic.
I've been here 14 months. I haven't never even committed this crime. They came and talked to me they came and talked to me yesterday and asked me some questions. And I talked to the detectives and they hit me with this. And the charge I'm in here with it. Now I never committed.
Your Honor, he's here on a lewd and lascivious battery that was revoked. This is an add-on charge.
All right. Sir, you may have some defenses to this. You'll have to discuss those with your attorney, but
Yes,
based on the arrest warrant that I reviewed, another judge has already found probable cause, and this court is loath to change that. So I'll not be changing that court's ruling at this time. But I am looking at the statute because I had the same questions the state had.
In sub 3, it contains the deadly weapon or use of actual force. So that's why I'm not certain if the firearm would have been further enhanced.
I think what I will do is I'll set a monetary bond. And then, he's being held at no bond on the other, so they'll have to have a hearing about it. The other judge can change it if they want to.
Yeah, Sean, that is what I was going to suggest. I would just ask for a high bond.
So you'll have no bond on count 3. Your bond on count 2 will be $250,000, and your bond on count 1 will be $150,000. Even while you're in custody, you're not allowed to have any contact with the victim's family members, or any witness in this case. Do you understand that?
Who is the victim?
State, can you give them the victim's name?
Yes, Your Honor. State would also ask for, I'll tell them also the witness's name. The victim's name is Ashley Fromporth.
Oh, you know who that is?
On 1, right, 250 on. Yes.
And the witness is Jessica Tomlinson.
You're not allowed to have contact with those people. Do you understand that?
Yes, ma'am.
You're not allowed to possess a weapon of any kind, firearm, or ammunition. You're not allowed to return to her residence for any reason or be within 1,000 feet of her. You're not I already said that. All right, good luck, sir. Please tell me your name.
Javier de Jesus.
21 CF 7144, you're here charged with possession of cocaine and resisting an officer without violence. There is probable cause, and I'll appoint the public defender's office to represent you. Your bond is $1,000 on count 1, $100 on count 2. You're not allowed to possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. Do you understand?
Yes.
All right, good luck, sir. No. It's 250,000, not 25. Yes, that's right. Please tell me your name.
Terry Jones Jr.
21 CF 6807, a warrant was issued for your arrest, charging you with fleeing or attempting to elude a law enforcement officer and resisting without violence. Another judge has already found probable cause. I'll appoint the public defender's office to represent you. Your bond is $15,000 on count 1, $100 on count 2. You can't drive without a valid Florida driver's license. Do you understand?
Yes, ma'am.
All right, good luck, sir.
Thank you.
Please tell me your name.
Gage Helmick.
21 CF 7108. You're here charged with fleeing or attempting to elude law enforcement officer with lights and sirens activated and grand theft of a motor vehicle. I'm going to appoint the Public Defender's Office to represent you in this case. There is probable cause. Your bond is $15,000 on count 1.
Your Honor, isn't fleeing and looting by itself a third-degree felony with a bond schedule of $1,000 to $2,500?
I don't know what the bond schedule says, Counselor.
I believe that's what it says, Your Honor.
I don't.
But still, a
Follow the
50,000
bond
is still
schedule.
far and away from that. I would have you set a lower monetary bound considering the third-degree felony.
Your Honor, the crime was inherently dangerous. The driver sped away from the traffic stop with the officer, I believe, still nearby, and accelerated at a high rate of speed in a stolen vehicle, and he also just pled to grand theft of a motor vehicle less than 2 weeks ago, about 2 weeks ago.
He does. Counselor, I also looked at your client's criminal history, which includes many felonies, many misdemeanors, a failure to appear, violations of probation. And so in this court's determination, a $15,000 bond on a fleeing and attempting to elude is a reasonable bond, but you can file a motion to reduce that in front of the trial judge.
Your Honor, what is the bond on count 2?
Count 2 will be $3,000. You can't have contact with any victim, witness, or co-defendant in this case. Do you understand?
Yes, ma'am.
All right, good luck, sir. Please tell me your name.
Albert Hughes.
21 CF 7140. You're here charged with possession of ammunition by a convicted felon, possession of cocaine, possession of cannabis less than 20 grams, possession of drug paraphernalia, and possession of a prescription drug without a prescription. I'm going to appoint the Public Defender's Office to represent you. There is probable cause in this case. I'll stay your bonds at $5,000 on count 1, $150 on count 2, and $100 on counts 3, 4, and 5. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand?
Yes.
You can't possess a weapon of any kind, firearm, or ammunition. Do you understand that?
Yes, Your Honor.
You can't have contact with any known drug dealers. And at this time, I'm revoking your out on bond case. You're out on bond for a felony case with very similar charges, and I'm revoking it at this time.
Nah, man, these officers, the same officers keep pulling me over. It's just the top, pulling me over. Can you reinstate my bond?
All right, sir, give me 1 second. Let me explain something to you. So everything you can ask me any questions, you can say anything you want, but everything you say is being recorded and can be used against you later. You understand that?
Yes, Your Honor.
All right.
Your Honor, I just
What did you wanna
give you
say?
a chance to say that I just bailed, the bail you gave me last time, the same officers targeting my car every time they pulled me over 3 times already. They're harassing me. Those items that they charged me with now, they've been in the car when they pulled me over the first time. It was 1 bullet, same prescription, everything is the same. So I'm asking you to reinstate the bail. It's the same charges, the same officers, the same police department harassing me.
Your Honor, in response to that, state would say that officers are allowed to make pretextual stops.
I can't hear you.
Law enforcement can make pretextual stops that is then supported by probable cause when there is a traffic violation.
I'm saying those
So what the
items, excuse me, Honor, those items been in the car when they first arrested me for the first charge. It was 1 bullet, the same pills, the same crumbs of the drug they found in the car, the same stuff been in that car 2 weeks ago. That's the same bullet was in my console, the same prescription, and now they pull me over again. Now they want to charge me with it again? Come on, man. It's not right.
Sir, the crime of possession,
Your Honor, that's
if you possess or consume an item, it doesn't, you can possess it more than once. And what happened is when they pulled you over, according to the probable cause affidavit, that's all I have.
Okay.
I just have a police report. So I'm just telling you there's probable cause. Now, if you think you have some defenses to this, you want to talk to your attorney about it, because there could be all kinds of things. You could file a motion to suppress, you could file a motion to dismiss, they could negotiate with the state and get the state to drop it, but all of that has to happen later. The only thing I'm doing here today is probable cause.
Your Honor, please, I'm asking you to reinstate because those items was there on the first case.
All right, hold on, let me look at this.
The bullet, my prescriptions, all that was there when they pulled me over when I got caught the first time. They pulled me over again. They didn't have nothing on me. The reason to stop me, first of all, they didn't have no reason to search my car, second of all. And now they just put these charges on me talking about he took the pills out, put them in the bag, put my prescription pill case back in my glove box. That one bullet, it was one bullet that goes to my girlfriend's gun, who's the owner of that car. He took the bullet out and charged me with it again. All this stuff is like, it's just, these sheriffs is bothering me.
Your Honor.
I nothing new about this case.
In the out on bond case, Your Honor, there is no charge for ammunition. There was a charge for a weapon, a Smith & Wesson 9mm pistol. There is no charge for prescription drugs in the out on bond case either, nor any mention of finding said prescription drugs.
No, there's not. What's the tampering?
Should have charged me when they first charged me, man. Ron, all I'm saying is no new charges being committed. Whatever happened with whatever happened with Your Honor, with me, that stuff was been in that car.
Okay, but I understand what you're saying, but that doesn't match up with what I have. So in this instant case, you were charged with possession of ammunition for a bullet. But in the case for which you're already out on bond, you were charged with possession of a firearm, not the bullet.
That bullet go to that firearm. That's my girl firearm. Sharon Wisner's firearm. She unlocked, she took the bullet out the chamber and it been in the glove box forever. When they first got the firearm off me, that bullet been in there.
But sir,
The firearm.
if you're a convicted felon, you can't be in possession of a bullet either. That's the problem. That's a felony.
So my question is this: the officer should have took the bullet out when they first arrested me for the firearm.
I don't know. I wasn't there when they arrested you. I would have thought they would have confiscated everything that was
They didn't. They left
in the car
They
that's,
left a lot of stuff in that car. They should have took.
Your Honor,
I'm surprised.
Respectfully, the firearm in the first case was a 9mm. The ammunition found in this case was a .380.
No. The first case, the gun was Sharon Watson. It was a .380. It wasn't a 9mm. It's false paperwork.
All right, sir. Listen, I hear what you're telling me, but I can't make sense of this because it doesn't match up with what I have in front of me. But I'm not saying that you're not telling the truth. You very well could be. So here's what I need you to do. I need you to call your attorney right away and ask them to file a bond motion for you right away.
I don't have an attorney yet.
You do. I have appointed the public defender's office, and they represent you in both cases. So what they need to do is file a motion and get it in front of the trial judge who has both of your cases so that that judge can look at what you're saying with all the facts. I don't have all of it here. I just have this limited amount.
Due respect, Your Honor, please consider the fact that these charges were there when they first arrested me. They bothered me 3 times since that arrest. Officer Parrish, Officer Serrano, Officer, they pulled me over for no reason yesterday. They searched my car, they didn't find nothing new. They talking about something old, all this stuff is old.
Listen, sir, I don't know and I can't give you legal advice, but if I was you, I might clean out my car.
To revoke my bail, Your Honor, is like siding with them, saying that.
No.
I'm saying like.
What I'm saying is you were out on bond for possession of a firearm by a convicted felon, possession of cocaine with a weapon, tampering with physical evidence, and resisting without violence. You were out on bond for that charge.
Right.
and then you got arrested for new charges that are very similar. But while you're out on bond, you can't get arrested for a new law violation.
So, to be honest,
So
that's
I
not
don't-
the same though, Your Honor. I can't explain it like,
I understand what you're saying, but I can't verify what you're saying. The facts are too different. What I have in front of me is different than what you're saying. So you're gonna have to take this up with the trial judge. So call the number on that green piece of paper and say you wanna talk
I
to,
gotta stay in this jail. They towed my car. I gotta stay in this jail, Your Honor.
yes, until your attorney files a motion and gets it in front of the trial judge. So call your attorney right away.
I don't know how to do all this, man.
Call the number on that piece of paper.
Collect?
There's a phone here at the jail you can use.
Honor, can you reconsider this?
I'm not going to today, sir. I'm sorry, good luck. Please tell me your name.
Michael Jean Pierre.
21 CF 7136. You're here charged with possession of a controlled substance, petty theft, and resisting an officer without violence. I'm appointing the public defender's office to represent you. There is probable cause. Your bond will be $1,000 on count 1, $500 on count 2, $100 on count 3. You're not allowed to possess or consume any controlled substance without a valid prescription. You're not allowed to return to the Wawa at 1200 West Colonial. You know where that is? You can't go back there. You understand? You can't have contact with any victim or witness in this case. All right, good luck, sir.
All right, well,
Yes, sir.
I was just wondering, can I get a R&R, please?
I'm not going to do that at this time.
Or PTR?
You don't qualify for pretrial release. But what you can do is call that number and ask your attorney to file a bond motion in front of the trial judge. That judge can change my order.
This judge's number right here?
No, that's your attorney.
Oh, is it attorney number? Okay, okay. Yes, ma'am. So, can I speak to my public defender now?
Yes, I'll give you a moment. Ms. May, can I see you? This is not about any case. But actually, Mr. Brands, can you send that email right now? Because let's see if we can get that moving. Wait, I don't have his paperwork anymore. What's his last name? Pierre. Just give us one moment. We're working on something. We'll finish his case in just a minute. That's Wilson. That's from earlier. Right. I just put it aside so we can call it later. We haven't addressed it.
Your Honor, I did get one. I just have to, I just need to send it to a JA if I can.
Ooh, Ashley Figueroa.
I can do that. Just waiting on the email, Your Honor.
Okay, let's go ahead and finish up with Mr. Jean-Pierre. All right, sir. I already reduced your bond in this case. I'm not going to reduce it any lower. Your attorney's going to have to file a motion in front of the trial judge. You understand that?
Ma'am, you said reduce it, but reduce it, what did you reduce?
I did. So on count 3, the bond was $500 and I reduced it to $100.
So you talking about the bond, my initial bonds would be 1,600 to get out?
Yes.
But that's what I'm saying, ma'am. I don't have 10%. I don't have 10% to pay a bond. I don't have no money to pay it.
I understand what you're saying, but sir, that's a reasonable bond.
No, I understand what you're saying, but Mom, like, I don't have no money. A PTR or R&R would be the best way to help me because I'm stuck in
can't do
jail.
that,
My
though.
parents are not here.
Right.
Nobody's here. I do care. I'm just here by myself, and I know this is a petty charge. And I didn't have no possession on me, so I don't even know why they charged me with that felony with possession of controlled substance. But ma'am, I'm trying to tell you, when I do get in contact with my attorney or my thing, we'll do a discovery and everything, and we'll do discovery. We'll run the background. We'll do it, see if we can get any evidence. I didn't have it. I know you read that.
Okay, hold on. Before you say anything else, I just want to make sure you understand everything you say is being recorded and it can be used against you later. Let me ask, Ms. May, can you put the factual basis for the controlled substance possession on the record so he knows what's in the probable cause affidavit?
So you say you asked for that.
She's going to tell you.
Okay.
On or about June 16, 2021, so just in regards to that count, Your Honor?
Just the possession, right?
A search intended to arrest revealed less than 1 gram of a white powder residue, which was located on a black bag that was slung across Pierre's chest. The officer recognized the substance to be consistent with illegal narcotic. White powdery substance was field tested using a field.
I can't understand you.
Sorry. 1 gram of white powdery residue was located in a black bag that was slung across Pierre's chest. Based on his training and experience, he recognized this to be consistent with an illegal narcotic. Using a field test kit, the officer determined it was field presumptive positive for MDMA ecstasy. All events occurred in Orange County, Florida.
So the possession charge is MDMA.
But ma'am, I didn't have no MDA.
Listen, I believe what you're telling me, but I have to go by the probable cause affidavit. So all I'm telling you is there's probable cause, but you've already said that you want to talk to your attorney and conduct discovery. I think all of that's what you need to do. But given everything that I have in front of me and your criminal history, which, if you can remind me, because I don't have it in front of me now, didn't it have several violations of probation and an FTA?
Oh, ma'am.
Yes, Your Honor. I had 2 failures to appear, the last being in end of 2019. Lots of drug charges.
But ma'am, can we look at it?
Lots of
Because I don't
drug
think
charges.
I didn't have no failure to appears in 2019. And my last drug charge was back in 2017, 2015.
I believe you, but
2019.
what the information that I have shows me that I need to impose bond conditions to make sure that you want to come back to court. That's why I'm doing this. But I've already reduced your bond. That's as low as I'm going to reduce it today. You don't qualify for pretrial release, so I can't order it. It's just not possible.
How do I don't qualify, Mom?
It's,
Yeah. No, man, I understand what you're saying, but I don't qualify.
you don't qualify. So call your attorney and you can work it out with him or her.
But ma'am, how do I not qualify? Dog?
You don't. And that's it. Please tell me your name.
Jama Jelani.
21 CF 7113, you're here charged with grand theft of a motor vehicle. There is probable cause. I'll appoint the public defender's office to represent you. Your bond is $2,500. You can't have any contact with the victim or any witness in this case. Do you understand that?
What do you mean?
So you can't talk to, call, email the victim or any witness in this case. You understand?
Yeah.
Your Honor.
Yes.
I believe the facts in the arrest affidavit suggest that maybe there's only probable cause for an attempt grand theft as opposed to a full charge of grand theft.
The statute for theft includes attempt. It's included in the statutory language.
It's endeavor to take, attempt to take, or take.
Right.
Very good. Just wanted to clarify, Your Honor.
You're also not allowed to return to West Point Commons Shopping Plaza.
Okay.
Or, is there another? named,
Winter Garden RV Resort.
that's it, all right, or Winter Garden RV Resort, you understand that?
Okay. All right.
All right, good luck, sir.
Can you just give me another moment, Your Honor? I'm trying.
I'm sorry, what?
Can I just have a moment? Having trouble with this order, if you can give me like 3 seconds.
Let's finish this, and then we can recess if we need to.
There you go, right there.
Please tell me your name.
Lucas Xavier Lopez.
A warrant was issued for your arrest in 21 CF 3666 for violating conditions of your pretrial release.
Yes, ma'am.
The bond set by another judge is $1,000 and $100 on count 1 and count 2. If not previously appointed, I'll appoint the public defender's office to represent you. Good luck, sir.
So I'm sorry. I can bond out.
I'm sorry?
I can bond out.
Yes, you have bond.
Okay. Yes, ma'am.
Good luck. Please tell me your name. One more time. 21 CF 7138. You're here charged with possession of a firearm in commission of a felony, possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, possession of MDMA. 2 counts of that. Possession of cocaine with intent to sell with a firearm, possession of cocaine with intent to sell or deliver, possession of cocaine, possession of cannabis under 20 grams, possession of cannabis with intent to sell or deliver with a weapon, possession of cannabis with intent to sell or deliver, and possession of drug paraphernalia.
Your
I'm
Honor,
going to appoint the public defender's office to represent you. Yes, Mr. Brands?
as to the charges of possession of cocaine with intent to sell, as well as the possession of methamphetamines, MDMA with intent to sell, I didn't see enough facts in the arrest affidavit to suggest that there was an intent to sell the amount of cocaine. There were no baggies. It was a very small amount. Same with the MDMA, a very small amount, nothing to separate it in a way to suggest selling. Further, the amount of money found on Mr. Monroe was $89, nowhere near the amount that you would usually see with a drug dealer.
Your Honor, in the bag, there was a small black digital scale, and in the smaller pocket of the bag, there was clear sandwich baggies.
I understand that, Your Honor, but I did consider that perhaps as with the possession of cannabis with intent to sell. The cocaine and MDMA may have been used for personal use. There's also case law to suggest that the amounts are so small that there wouldn't be enough to hold a charge of intent to sell on the cocaine as well as the MDMA, excuse me.
You're arguing that as to probable cause or beyond all reasonable doubt?
The probable cause, Your Honor. I do see enough probable cause for the cocaine intent and MDMA intent, at least enough for possession, but not intent to sell.
So you're arguing that the court can only find probable cause as to the possession of marijuana with intent to sell because the intent to sell paraphernalia can only go with the cannabis?
The evidence suggests that perhaps the 5 baggies of marijuana suggest probable cause of intent to sell, but I do not find that same evidence for cocaine and MDMA. I think the amounts were too small. They weren't in separate bags.
Your Honor, he had indicia of sale in bags where drugs were located. Just because he had a pharmacy of drugs, just because some of them are not already individually packaged does not mean that there's not intent to sell and deliver. And the contention that he didn't have a lot, the crack cocaine was already divided into multiple pieces and weighed 2.6 grams, which is a fairly significant amount of cocaine, Your Honor. 2.6 grams could be sold to many people.
Your Honor, can I produce some case law on this? There's a very helpful paragraph with multiple cases suggesting the amounts with intent to sell, if I may approach.
Your Honor, in this case, there's more than just amounts.
There's no what?
There's more than just amounts. There's
There is.
indicia of sale.
I'm only arguing PC for the two charges of possession of cocaine with intent to sell and possession of MDMA with intent to sell. I just don't see that there's enough. If I may approach, Your Honor.
With the money, the guns, then being divided up into other,
The amount of money was low too, because a lot of cases have them being found with $400, and that's still not enough to uphold the charge.
right, I'm not suggesting any one of those things is enough. Let me see your case, Counselor.
But I'm considering the totality of circumstances, Your Honor. If I may.
Yes. Thank you.
I don't need it. I know what case you're referring to. There's no indicia of sale.
All right, so I'm reading this McFarland v. State, 239 Southern 3rd at 1272. It's a second DCA opinion out of 2018. I'm looking at the highlighted section, Counselor. I appreciate the highlights. It was definitely much easier to find what it is that you wanted this court to read. But nothing in this case suggests that this is not probable cause.
Your Honor, part of my job is to argue the probable cause for all charges. I look through all the charges and I consider PC. I consider what you would think PC. I consider what I can persuade this court about probable cause, and I'm just doing my due diligence in arguing the probable cause. I still think that with those cases in mind, that there wasn't enough to charge with these intents to sell. Even though he might have some for personal use, I don't think that's enough to charge for intent to sell, at least with the MDMA and the cocaine.
All right, thank you. I appreciate the argument. And the case law, I disagree with that, but I do have some questions for the state.
Regarding the two charges of MDMA?
Right, count 4 and 5?
Yes, Your Honor. I believe count 1 is due to the blunt. It was marijuana and MDMA, and then he later found MDMA in the bag.
So
I
the
believe
two
it
different
was-
locations of the MDMA?
I believe that's what the charges are from. I understand if you want to ROR on the second or lower, find it as a subsidiary, but I do believe that was the officer's intent when he charged it, is some that was actively in the blunt, and then some that was found later within his.
And then the same on counts 10 and 11?
Is that the cannabis?
Oh, no, that's with a weapon and without. Oh.
And the cannabis arguably is the same as well. There was some in the blunt, and then there was some found after search intent to arrest. And the weapon.
And 6 and 7?
I believe.
And 8? Is that the same cocaine?
I believe he opened a large pocket of the bag and found crack cocaine. And then he later found other. One second.
I'm going to treat those as subsidiaries, Counselor,
That's fine, Your Honor.
because the court is struggling with those right now.
Understood.
So, Mr. Monroe, your bond on count 1 will be $5,000. Count 2 will be $4,000. Count 3 will be $150. Count 4 will be $7,500. Count 5 will be $150. Count 6 will be $15,000. Count 7, 150, count 8, 150, count 9, 150, count 10, 15,000, count 11, 150, and count 12, 100. You're not allowed to possess or consume any controlled substance without a valid prescription. Do you understand that? You're not allowed to possess a weapon of any kind, firearm, or ammunition, and you're not allowed to have contact with any known drug dealers. At this time, I'm also revoking your out on bond cases.
Your Honor, and on his out on bonds, he's only out on bond on the misdemeanor case. The felony case was no info yesterday.
Okay, so I'm only revoking it on the misdemeanor then. Thank you.
Thank you for your consideration, Your Honor.
Yes, sir. Thank you for the case law. Please tell me your name.
Ilson Murray.
You're here in 20 CF 1938. A capias was issued for your arrest for failing to appear for a status hearing on charges of burglary of a dwelling, criminal mischief, and resisting an officer without violence. There is no bond authorized on this capias, and I'll appoint the Public Defender's Office to represent you. Yes, sir.
I was in Leon County at the time.
In jail?
Yes, ma'am.
Okay. I believe you, but I can't change another judge's capias, so what you need to do is call your attorney right away on that number and have them file a motion in front of the trial judge. That's who can change it. Good luck, sir. Please tell me your name.
Ryan Presley.
21 CF 7132, you're here charged with robbery. I'm going to appoint the Public Defender's Office to represent you. There is probable cause.
Your Honor,
Yes?
given the bond, it is an F2. I don't believe that $5,000 is reasonable, given the facts in the affidavit. They're rather violent in nature and taking into account his history.
Your Honor, it was
Yes.
also $12 worth of merchandise.
That they were able to reobtain because he dropped the rest of it when.
All right, sir, you can say anything you want or ask any questions that you have, but everything you say is on the record. It's being recorded and can be used against you later. You understand that? All right, I've appointed the Public Defender's Office. Why don't you speak with him for a moment? Counselor, why does the face sheet say this is a PBL?
It's not, Your Honor, the way it's charged.
Right, is there something else?
Under 2C, it's not. As there was no firearm or deadly weapon.
Right, I didn't see anything in the affidavit. I didn't know if there was something I'm missing.
I believe it was BTR just saw the charge and I maybe assumed, but it's an F2. But given his history, he has a homicide from 2005.
A conviction?
Yes, Your Honor. It was an adjudication.
It was
out of
what?
Pasco. An adjudication out of Pasco. And continues to pick up petty thefts, which arguably is similar to the facts here.
Your Honor, our only concern is the affordability of the bond that's set at $5,000. He was, I don't even believe he can afford 10% of that. If you would consider lowering the bond to consider his income status.
Counselor, this court has to consider all of the everything that's in the statute for bond, which includes criminal history, it includes prior failures to appear, and it includes balancing your client's rights against protecting the citizens of Orange County. This was a very violent crime. He has a very violent history. So
I understand, Your Honor, and in speaking with him, I know he understands the seriousness of this charge, and I've explained to him that even today, we can't go over the facts and build his case, but his attorney at our office can. The only issue I have is, of course, the affordability of bond, and as earlier this week, I had issues with arguing the affordability of bond for our clients, that if it's too much for them to afford it, you may as well hold them at no bond. If you would consider if he filed a affidavit of insolvency, it shows that he can't afford his own attorney. If he has no friends or relatives that can provide money to bail him out, then he is stuck here.
Counselor, I think that you'll have to present that evidence to the trial judge at a bond hearing.
Your Honor, he's failed to appear as recently as May 26th.
Of this year?
In one of his petty theft cases. He currently has a resisting without open and a petty theft open. The petty theft he picked up in February, and he failed to appear at a plea hearing on May 26th. And he has prior failure to appear history.
All right, Mr. Presley, here's what I'm going to do. Your bond is $5,000. The state's asking me to set a higher bond. I'm not going to do that at this time, but I will not reduce it. You're not allowed to return to the Dollar General at 3986 South Orange Blossom Trail. You know where that is? You can't go back there. You understand that?
Yes, ma'am. I'm not going to be able to go anywhere.
You can't have any contact with the victim in this case. You can't possess a weapon of any kind, firearm, or ammunition. Call your attorney right away and have them file a motion for you, sir. Good luck. Please tell me your name. What's your name?
My name is Douglas Scoglin.
21 CF 7133, you're here charged with possession of cocaine. There is probable cause, and I'll appoint the public defender's office to represent you. Your bond is $1,000. You can't possess or consume any controlled substance without a valid prescription or have contact with any known drug dealers. In 21 MO 689, you're charged with open container of an alcoholic beverage. There's also probable cause for that. I'll appoint the public defender's office in that case as well. Your bond in that case will be $250. Good luck, sir. Please tell me your name.
LaQuisha Womack.
A capias was issued for your arrest in 21 CF 7062 for failure to redeliver hired or leased personal property of $300 or more. The bond on that is $1,500, and I'll appoint the public defender's office to represent you. You can't have contact with any victim or witness in the case or co-defendant. You can't drive without a valid Florida driver's license. Do you understand?
Yes, ma'am.
Yes, Mr. Brands?
Your Honor, on the out on bond case, I was looking through the PC documents for the affidavit and the current charge. I believe that goes all the way back to September of 2020, and her out on bond case she wasn't bonded out until October 2020, so it isn't like she's committing a new law violation while out on bond. This is a past violation that it looks like she's out on. So chronologically, I think you should take no action.
She was not out on bond on that case, is what you're saying, because of the dates.
Correct.
I'll take no action on that.
Thank you, Your Honor.
Good luck, ma'am.
Thank you so much.
Yes, ma'am. All right, if we can bring Mr. Wilson back, were you able to get that motion?
I did. I sent it to Ms. Figueroa.
Oh,
She said she received it.
did she say she would bring it in here?
I didn't get that.
She brought something else, but she didn't bring that.
I also had other business if you want to consider it.
What?
There was, I didn't want to add anything to our docket tomorrow, so I was wondering if you would consider a 33-day motion for Elliot Castillo's 2021 CF 4146AO.
I don't have that.
I had an attorney message me to, he filed it for tomorrow.
If it's not on the list, we're not gonna be properly noticed and we're not gonna
So if you
respond.
filed it today, it'll be on the docket tomorrow? Okay, perfect.
I don't know. Is it too late in the day for it to get on the docket? I don't know.
The PD's office has already sent both, all of their stuff, so most likely, yes.
So you're gonna have to
They already sent both emails.
talk to your office in the state who does that, because the state has to research it, and then we can have the,
What was the last
He
name?
is on the docket. He's number 7 on the auto ROR list for tomorrow.
Then it'll be heard.
It will be heard then. Okay, I was just double checking, sorry. Yeah, I just got that update.
okay, hold on. Mr. Wilson, give me one more minute, okay? What about 21 CF 4124? I end Paul. I don't know why I have this order.
Can you give me the last four again, Your Honor?
4124?
May I approach to see it, Your Honor, just in case?
Oh, is that what you, that's,
It shouldn't be. I double checked the order before I sent it. It was Mr. Wilson. So I don't know what that order is pertaining to.
I think she brought the wrong one.
You have a motion to quash for Mr. Paul?
She thinks that's what you sent.
Really? Okay. Let me send it again.
Hold on, Mr. Wilson.
You know why? Because I sent the wrong one. That's why.
He's checking now. It's supposed to be in order to quash a capias.
Your Honor,
I
can I
sent the
just
wrong-
print it?
Do you have it?
I have a printer.
Can I send it?
Yeah,
to
print
you?
it.
I didn't know if you wanted it to go to Ashley for.
No, no, no. All right, so this is Mr. Wilson, 20MM 7748. Mr. Wilson, we're addressing the capias that was issued for your arrest for failing to appear for the petty theft on June 14th, 2021. The attorneys have both researched this and can verify that you were in fact in custody at the time. And this court was in contact with your trial judge, Judge Dubois, who granted the motion to quash the capias. So as soon as I get that order, I'll quash that capias. So you still have to deal with your MDMA case. You understand that? This doesn't affect that case at all.
Will this case,
Get close to the microphone.
the petty theft, will it be relinquished today?
No, it just means that you won't be held on, you won't have to post this bond because Judge Dubois quashed this capias.
Okay,
So the petty theft is still pending and the MDMA case is still pending.
okay.
It just means you won't be held here on this petty theft and have to post that $500 bond.
Yes, ma'am.
May I approach, Your Honor?
Thank you so
Yes.
much.
Yes, sir. When we find things like this, we try to fix it whenever possible.
Yes, ma'am. Appreciate it.
Oh, what is it? Because I need that in here.
Division 82 pretrial conference, July 26th at 10:30 a.m. in 10B.
At what time?
10:30.
All right, sir. So your next court date on this petty theft charge will be in front of Judge Dubois on July 26th at 10:30 a.m. Your attorney should know that, and if you're still in custody, they'll transport you down there, I think. Because we are transporting now.
So are we RORing, Your Honor?
I mean, if I quash the capias, there's no bond issue. So I don't have to ROR him, the capias disappears.
Okay.
Right?
I would assume.
Because he's being held on the capias with a $500 bond. I quash the capias, the $500 bond is gone. So effectively, he's released on this charge, just not the possession charge. Yes. Because he didn't post the bond in the possession charge, right?
It says he's still being held on it, I believe. $1,000 bond.
Yeah, so he'll still have to post that to get out, but he doesn't have to post the 500.
He is released in his own recognizance, Your Honor, on the.
On this charge, the petty theft.
Okay.
So you still have the possession of MDMA. If you have not posted bond on that, you won't be released. You understand that?
Right,
Okay. But on this charge, you're not being held, you don't have to post bond.
okay. So, after today, get a bond on it.
It's effectively the same thing. I'm not. I don't think we need to write that on the order. Right?
Yeah, my concern
Okay,
is
just write it on the order.
it
Let's just do
catching
it.
up.
We'll do it, and that way it's really clear. Does everyone understand what we did?
Yes, Your Honor.
Okay. Mr. Wilson, you understand?
Yes, ma'am.
Good luck, sir.
Thank you, ma'am. Thank you so much.
Yes, sir. You as well. Is there any other business before the court is adjourned today?
No, Your Honor.